You're fine. You're live.
Are we muted? Good evening. I'd like to go ahead and welcome everyone to the February 11th election night meeting of the Cobb County Board of Elections. The time is now 7:04 p.m. and I will call this meeting for that time. The first item on this evening's agenda is the approval of the agenda. And so have all board members had an opportunity to review the agenda? And are there any proposed amendments to the agenda? Thank you. There being none, I'll entertain a motion to approve the agenda.
So moved.
Thank you, Mr. Bruning. Is there a second?
Second.
It's been moved and properly seconded to move the agenda, to approve the agenda. All those in favor, we'll just do a simple aye vote.
Aye.
Any opposition? The motion passes unanimously. The next item on the agenda is public comment. I know that earlier today, Director Paul advised that there are no people that have requested to participate virtually. Okay, excellent. And then I do know that we have one person that is participating here in person, Ms. Riddle. Wait, I'm sorry. Being out of sorts just a bit in this location for this meeting, I did not do the Pledge of Allegiance. And I will note that in this room, we do not presently have a flag, but we do have one that's just right outside. So I invite all of those that are willing and able to rise with us to recite the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, and pardon my omission. Just jumping right into the business of the board. Ms. Riddle, now, if you will please go ahead and provide your public comment, please.
Hey, Sally Riddle, resident of Cobb County. So looking at the agenda tonight, I noticed that there are two possible approaches if there is a runoff for voting locations for advanced in-person voting. So consequently, I'm just asking that the proposal that, again, if a runoff is necessary to be held in District 2, that the two location option be accepted. I recognize that the voter turnout has been extremely low in this election and is likely to be low in a runoff as well. But also recognizing that some voters may decide to participate in the runoff because they now learn about the election more, who did not vote during the initial election can happen. But also, given the interesting shape of District 2, it is a very large geographic spread. And so consequently, the Smyrna Community Center and this main office actually are not that close together. And so it'd be good to have people be able to have the two options of where they go to vote, particularly since there's a lot of people who seem very tied to the Smyrna Community Center when they go to vote there. Thank you.
Thank you, Ms. Riddle. I, for one, am one of those that are tied, as I live just a mile or so away from the Smyrna Community Center, so that makes perfect sense. And the other board will take that under consideration. Moving on to the next item on the agenda, approval of the meeting minutes. Has everyone had an opportunity to review the meeting minutes from our January 13th regularly called meeting? Yes. Does anyone have any proposed revisions? And if there are none, go ahead and entertain a motion to accept to approve the meeting minutes as provided.
So moved.
Thank you, Mr. Bruning. Is there a second?
Second.
It's been moved and properly seconded to approve the meeting minutes as provided for our January 13th regular meeting of the board. All of those in favor, just an aye vote? Aye. The motion passes unanimously. Thank you. You are up, Director Paul, with your update.
Well, to start us off, right now our numbers today are looking at 5,640. That might increase a little bit as the poll paths continue to sink at the end of the day. So for election day, that puts us at 2.35% turnout. And then when we combine that with AIP and ABM, that puts us at 8,982, which puts us at 3.74%. I know that the 5:30 p.m. We mailed out a total of 50 ballots and 42 of those ballots have been returned. One of them can't be counted until it's cured, so 41 of them will be counted. So great return rate off the ballots. We're really happy about that. One of those voters, outstanding ballots, did vote AIP, so there's really only 7 outstanding ballots. So that's really great. So we'll see those numbers posted pretty quickly on our website. Results for AIP and ABM. And then for the AIP proposal, I'm just going to share my screen. So we put together 2 different proposals. The only possibility for a runoff is in D2 in the Democrat race. They have more than 2 candidates. We'll know in a few hours, but we want to go ahead and look at this. So we have one proposal with just our main office open. What we typically do for a runoff is the Monday to Friday, 7 a.m. to 7 p.m. That's the standard runoff dates and times that we've done in the past. And then the other option would be for both options that were open for early voting for this election, main office and Smyrna Community Center from Monday through Friday, March 3rd through 7th, 8 a.m. to 6 p.m. Just since there's 2 sites. So obviously the decision is the board's, but these are the 2 proposals that we had discussed.
Thank you, Director Paul. Board members, you all have any? And yes, Mr. Bruning, go ahead.
My only comment is that the Smyrna site actually had more voters this time than the main. So, and it is, there's a big chunk of this district that's closer to Smyrna than it is to here. So I would agree with Ms. Riddle and say we should two locations this time, if we have the misfortune of having.
I'm a big believer in consistency. I just think it should be the same as what we offered.
Yeah, that would be my comment as well. And I do understand the proposal with respect to having two locations, therefore taking an hour off the start time and an hour off the end time because you have the additional location. But I believe definitely Ms. Mosbacher, since we've been on this board, we've worked really diligently to set some standard timeframes. And I believe voters are likely to be accustomed to that. And notwithstanding Tammy in the office working hard to communicate whatever schedule it is. If we veer from the 7 a.m. to 7 p.m., I've put money, not a whole lot, but I put money on the fact that some folks will be showing up at our locations at 7 a.m. because I believe that we began to set those expectations. And those expectations are likely with our voters at this point. So that would be my comments with respect to this. In addition to what Mr. Bruning said, I do believe, and it's not a personal preference because I vote there, but I do believe we likely should be offering early voting AIP at this time.
I agree with that. I think the consistency, and I believe in multiple locations.
All right, that being said, is there any additional, I guess, discussion with the team that you want to have? I know that we likely take this vote this evening, given the imminency of the potential for a runoff. So what is the proposal, just so that we are all on the same page? I believe it is Exhibit A, or the proposal is set forth in Exhibit A, which allows for voting, advance in-person voting at the main office, as well as the Smyrna Community Center, March the 3rd through the 7th, with the hours of 7 a.m. to 7 p.m.
And just to point out, there's the pages are labeled today.
Oh,
So it's the one that has two locations.
I just edited it on the screen, so
okay.
what's up on the screen is.
Yeah, I mean, it did say two locations.
Yeah.
I don't understand why there'd be two Exhibit A's, but there are. Anyway, go ahead. So is there a motion?
I move that we approve the AIP schedule that has location at Smyrna Community Center as well as here at the main.
With the time,
Hours 7 to 7, 5 days, Monday to Friday.
thank you, Mr. Bruning. Is there a second?
Second.
It's been moved and properly seconded to set the AIP advanced voting schedule in the event it's necessary for a special election runoff in District 2 to be held on March the 11th. The AIP voting would be held at the main office, as well as the Smyrna Community Center on the dates of March 3rd through the 7th from the hours of 7 a.m. to 7 p.m. All of those in favor? Aye. Any opposition? The motion passes unanimously. Thank you, Director Fall, as well as to the board. Are there any questions for Director Fall with respect to her update or otherwise?
I'd just like to ask any glitches that have come about this week?
No, it's been pretty quiet. I emailed the board earlier in one of the updates about the only issue that we saw in a few precincts was with the poll pads not showing the oath on the screen, but when it was printing, it was listed there. So all of our records are good to go. It was an easy fix. We just had to hard reset the app. For those precincts, it was 9 that had called in with that issue, but we called several others and they did issues. So that was it. It was a really.
Did they have any syncing problems with Jarvis?
No, we didn't have those issues we saw in November, both in AIP and today. As far as we saw in AIP, everyone moved over and Jarvis had credit, 1-for-1 perfect. And then we'll see as we finish up today when they're done syncing tomorrow what the sync looks like. But no issues in AIP like we had.
That's improvement. Improvement is good.
Yeah.
No, improvement is great. We'll take improvements where we get them.
Even though we didn't know about them.
Right.
At least I missed that memo if we did.
No worries whatsoever. Updates any with respect to your communication to us maybe a couple of hours ago about precinct cards?
Sure, so we got the first batch of return precinct cards today. We always expect that when we do a countywide mailing because we mail them to both active and inactive voters. So we expect those inactive voter cards to come back. We want to be able to log that as an interaction in their voter record. And so when the front desk reception staff was starting to sort those out, we sort them by in-state, out-of-state because they're logged differently in Jarvis. And they noticed that there was a yellow label on some of them that they had never seen before, and it said postage due, return to sender. But they were all postage prepaid, and there was no reason why that should happen. We obviously had, we mailed out almost 600,000 postcards, and a small group of them were returned. It was 1,427 is how many were returned today. So I have a few ideas of how that could have happened. It's no fault to us or to the vendor because postage is set by USPS. They approve the postage ahead of time, and the way it works is that in order to get the pre-sort discount, the vendor sends the pre-sort list to the USPS and in the order of zip codes of how the printing is laid out, and then USPS sends the rate back. And so they approved the rate, they told us what it was. So we've never seen that error ever on a postage on our mail out like that before. Like I said, I have an idea of a few ideas of what it could be, but we don't have any concrete proof of how it happened. And so started our contacts with our local postmasters here to try to get an understanding, and have been in touch with them here and there throughout the day, but haven't gotten a response on that specific question. So we'll be working with USPS and potentially launching a postal investigation into what happened and how that could have happened.
Okay.
Wasn't that the same issue that occurred the first time around with no ink mailing the cards?
We've never had this issue.
Well, we didn't use them the first time around, but
They
there
mailed-
were counties
they mailed
all over the state that did have that.
They did all
issue.
of the voter list maintenance mailings last summer, and we didn't have this issue with them. And that was to all the voters again.
So just looking at the image of the label, it says postage due, then it says return to sender, no such number, unable to forward. Do we know what NSN, no such number means? Okay.
Yeah, like I said, we've never seen that label before. I sent a picture of it to our local postmaster here, and I haven't heard back from him. That was a few hours ago on how that could have happened or what it even means. And so we'll obviously have a lot more conversations with them. I'm going to take over a bundle tomorrow to USPS in the morning and talk with our local postmaster and see what kind of answers I can get.
Okay.
Do we know the breakout on active versus inactive voters on this 1,400?
Oh, no, they came in today, so we've only had a chance to sort them and count them. I haven't checked in Jarvis. There's no indicator on the card that says whether they're active or inactive, so we have to look them up in Jarvis.
Are you planning on doing that?
I wasn't. That'd be a lot of work. But
So is having 1,400 cards.
my goal
returned.
is to have the USPS refund us and then resend those cards.
Is the 1,400 with that label or 1,400 total return today?
Working on with that label. We had a lot more of the regular, what we see the out-of-state in-state return. Okay, yeah, we had about 10 to 12 trades coming this morning.
All right, but the
Yeah.
1,400 is, there are 1,400 right now that came in with that yellow label.
That says return to sender postage due.
And we could get more of those.
Yes.
Obviously,
Yes.
so.
Well,
I guess my concern is I have mine. My choice. But I have mine, and presumably the same postage that is attributed to mine allowed it to be delivered.
Right.
Notwithstanding these 1,400, I'm uncertain. I guess I'm curious, and obviously in opening up an investigation and speaking with our postmaster, I know that you received yours as well, correct? So,
I got mine.
and you have yours, so if it was enough postage to get to the three of us, I guess the 1,400, why wasn't it enough postage to get to them when it should have just been a flat?
I suspect that that it's a mislabel and that I think that my first guess would be that they just labeled them to return them instead of delivering them.
Okay,
Because we mailed almost 600,000 postcards and we're at this table got theirs and these 1,427 were the only ones. It's just, there's no sense there as to how that's even possible.
Just as a further post office. And
right.
on the same day that Stacy sent your email that you had gotten yours, which I think was last Tuesday. Is that right? Anyway, I was all excited. I actually walked down to the mailbox to receive our mail from the postal carrier. I had gotten the notice of the email notice, the preview that showed the cards in there, and I was excited that we were going to get them. It came finally today.
So I spoke to someone else today who said she talked to a lot of people who also saw the postcard in there. Informed delivery. And they still had not received it. And it was very bizarre because you would think that if it's in your informed delivery, it's like in your bucket.
Yeah, that's part of the concerns. I think that there's a disconnect from when the mail was being scanned and put into informed delivery and somewhere with the postal carriers. Because these 1,427, it's not all one zip code. It had Kennesaw, Mableton, Marietta. It was all over. It wasn't one zip code. So I think it's a breakdown at the postal carrier level. But like I said, I don't have any facts right now about how, but we'll investigate it and make sure that USPS investigates it as well with the postal investigator.
So your guess on the total return mail would be just a rough estimate?
I would say, I mean, we definitely have the totals up front. I would say maybe 3,000 is what we got today, because we got about 10 to 12 trays. So,
That's out of 600,000.
yeah, today. I can get a final number because they do batch them and batch the 50. So we'd have a final count on all the different sorts, but I can get a final number of what came back today. They'll continue to come back, of course. But I can let you know how much we got today for sure.
And not wanting to create more work for anyone, especially at this time, but recognizing that margins are likely to be very small with respect to, who is successful. This evening, I guess I just have some concerns about any of these that were returned in this particular category, not your typical entity out of state, being those voters that didn't receive their precinct card, but were eligible to vote in today's election. And with such a very low turnout, it's just something we should likely keep our eye on. So, does anyone have anything further for Director Paul? Okay. Thank you very much. Thanks. Great. Moving on to the next item on the agenda, old business. So the first item under old business is our bylaws. Recognizing that we initially wanted to take up and amending and restating the board's bylaws in August of last year, that did not take place. We ultimately determined that we would postpone this discussion until after the election, that being the November 2024 general election. Everyone should have the version that was circulated on the 2nd, I believe, on Sunday, February the 2nd, prior to its publication along with the agenda for this meeting, I believe that following day. So that is what we all should. To the extent that you have it in front of you, I don't need to put it up on the screen, or are we?
To you and I do.
Okay. Okay.
Some of us in larger type.
Great. So if that's the case, Because that was the only reason that I joined the WebEx, to the extent that we wanted to share a screen to attempt to replicate obviously what we have available to us in the BOC room.
Do you have it? Can you put it up actually in color? Because we.
Yeah, I have it in color.
Yeah, 'cause you have it in color, but I feel like that might be helpful.
Okay, sure.
If you put it up there, does that mean people following along online will be able to see it?
They should, but I don't know that question. We should, because WebEx is being streamed. And if I share my screen, if you,
And I would say put it up.
yeah, which is the reason why.
Yep.
I inquired. Okay, there we are. Are you all following along on your own WebEx?
Oh, that have the paper.
Okay. I have notes, so I can't make it too large. But I believe, well, let's talk about the most efficient way to get through this, as we have a couple of documents to get through this evening. Everyone has had an opportunity to review it and weigh in. And the comments as provided by council are at least on mine. So is it, I think just going through it and suggesting what should be like by provision, vote up, vote down. And if there's a proposed revision or a need to have conversation, we can talk through rationale for proposed revisions and go. Are we in agreement with that, or?
I would suggest. I don't know about others, but I find this very hard to follow.
Okay.
As to what the final product will be. So I would suggest tonight, we.
Just
look up
discuss.
and
Yeah.
have on individual paragraphs.
Yeah.
And then have this a clean copy provided,
Mhm.
and then that be voted on at the next regular meeting. If it can be done that.
Yeah, I'm ready to get this one done. It's been out there for quite some time, so I'm happy to invest the time to, in collaboration with our council, to get it done. But yes, I agree. So it indicated that we vote up a provision or vote down a provision and go from there. Just wanna be certain here. All right. So. Article 1 should not be of any controversy. Moving on to Article 2. This is the purpose, powers, and duties. The red lines, the red lines, as you see them, are proposed revisions provided by our council. And I note that, Daniel, in reworking that provision, you noted that our powers and duties are those that are listed in OCGA 21-270 and other parts. You indicated that we could restate some of these powers if we wanted to, but to the extent you list some powers and duties that aren't expressly provided for in those laws, like education, budget review, and advocacy, you want to keep them separate. So does anyone have any objection to Section 1 reading as follows? The board, as the entity charged with the conduct of primaries and elections and the registration of electors in Cobb County, Georgia, is empowered with, and then all of the language that runs through with those powers granted to it under local law. I hate reading to people, but,
Sounds good to me.
okay,
I'm fine with that.
all right.
And Daniel, that's your ribbon, that's part.
That's my revision.
Yeah.
Just to explain,
Yeah,
this had all been lumped together as, well, then a short thing up at the top, just like the purpose, and then there was another one that was responsibilities and duties. And I think Tori originally borrowed this from Cobb or another county or something like that. And I was kind of surprised, like, that some of the, when you call something a duty, that implies that it's given to you by law somewhere, and like you're sort of reciting it. And so I better go double check. So when I compared it with the powers, there's an expression of the powers in 21-270, and then there are other things in the election code that says superintendents do this. But for as far as I can tell, some of the things about like education and budget advocacy and those kind of things, those are very important things for this board to be involved in, and good objectives and goals and things. They're not necessarily your legal responsibilities and duties. And so you can't, in your bylaws, you can't like make yourself have a duty or a power that you don't have in the statute. So I just said, let's just recite the areas where you get your powers and duties from. And then you can go through and list like, those things that are related to it.
so basically this section, Article 2, Section 1 is purpose, powers and duties, and then the title is purpose, powers and duties. Is that kind of?
Yeah.
Okay.
The Article 2 is now purpose, powers and duties. Section 1 is purpose, powers and duties. And Section 2, you get
Responsibility.
I think I had put objectives and goals, and I think
You have.
it's now resorted back to responsibilities and duties.
Stacy redlined it out
I
and
have,
put responsibilities and duties back in there. I think objectives and goals are what needs to be there such that it's one, not duplicative. And you specifically redlined out responsibilities in the article heading, So, and noted that objectives and goals are most likely the appropriate heading. And, I don't want us to get bogged down in form over substance, but yes, that's what transpired.
so basically just calling Section 2 objectives, is that?
Well, whatever, I had recommended some language there. I wasn't sure why this next version had that, but I had said, call it objectives and goals, and then that language that says in furtherance of the board's duties and responsibilities.
The board sets forth the following objectives and goals. So Stacy, you redlined it out. Is there a rationale for
Well, I think
redlining it out?
I think I was just trying to simplify to make it just the board's duties and responsibilities include, and then going straight into.
Well, that's what I was pointing about. It's like, you can't, if these things aren't, these are things that you can do and in furtherance to those, but if you're saying these are our powers and duties, it feels more reasonable to reference the code or local law. Whereas these other things like the, budget advocacy and things like that, and it's weird because there's a mix of things still in here that are sort of responsibilities that are yours, like appointing and removing the director. That's in the local law, so that's one of your powers.
Well, so I think part of the reason that I thought it was good to spell out some of that is, as a new board member, when I came in, just going back and referencing the code is a bit intimidating. So if we spell out some of the main functions of the board, in the this is the document that like we all get and receive in our notebooks. We get our code books, but it's daunting to start. I'm not an attorney, so to start.
It's not for attorneys too.
So, to me, when I got this, mimeographed bylaws document, I mean, this was really the first thing that I read to try to understand what it was that was my role. So I think just alone referencing the code is fine, but I think laying out some of the key responsibilities of what we do here, like, I think there were a few that made sense to spell out because they're primary functions.
And are you referring to what's in Section 2?
Right.
Okay.
Where it says like,
I guess I understood those to be yours and Stacy's revisions per her email.
yeah, that's
Such
what I'm
that
saying.
you all were fine with taking them out.
Right, there's some in and some out, right?
Okay.
That's what I'm saying, like, there are certain things that it seemed to make sense, like Daniel just pointed out that, that we're responsible for providing policy guidance to the election supervisor. Like that's one of the things that you often tell us is that we are charged with policy guidance, right? So I feel like spelling that out makes sense.
Yeah, and I want to say that's how it was drafted, I believe, in Gwinnett's. There it is. Yeah, it was in Gwinnett's, if I recall correctly. So, I mean, I guess the only other suggestion here, maybe we spell some of it out, but include the reference. The thing with spelling it out, to the extent, I would imagine none of this would be removed from the code provision. But I think the benefit with referencing the code provision and maybe including some language, including but not limited to, is if they make changes to the code provision, your bylaws are always up to date because it refers back to the governing
I
document.
think there is a line in there that if the two conflict, the state code fails.
Right, but what's in your bylaws is incorrect. And to the point that Jennifer just made, if members are referring to this, and even with the state code prevailing, if board members that are less likely to look at the code provision aren't going to go to that prevailing state law, they'd be relying upon information that's incorrect in the bylaws.
I did find it, in the Gwinnett, bylaws.
Mhm.
We had taken, Article 8 responsibilities A, and I can pass this around if you want.
I have it here.
Copy and pasted it into section 2A there.
And it's fine. I don't see what you're doing. It's like you basically just took, and there were other things in there like the budget advocacy and the education. And y'all just taking those out. And now you're just calling it like, so if you want to do that, just leave, you can just call it responsibilities and then just leave your restated A and your restated B.
And C just deals with the forming of committees. And I think that's actually in our current one.
It was, no, it wasn't in the current one. It was in section, in what I proposed, it was in Article 5. We simply deleted Article 5 because Article 5 wasn't in, Article 5 was among, it wasn't in the original.
Right.
It was
I
in
think
what I
we moved it
proposed for it. Yeah, so we just simply deleted it and moved it up.
Because it is more
Consistent with, exactly. So I do have a couple of, so I guess going back to what is subsection A. I would assume the board is only going to be acting in its legal capacity, and I understand that's the language that's in Gwinnett that we cut and pasted in there, but is it necessary, Daniel, to say that the board is acting in its legal capacity? I don't know what other capacity we would be operating in.
But that was important to me to know when we got on the board, that it was, that our actions were as a board and not individuals. Like
Then that would be board members and not necessarily board itself, so, but yeah, I don't know, I'm fine with that.
Well, I think the reason Gwinnett probably had it in there
Mhm.
and it's fine, I'm fine to leave it, is that it's probably a way of saying like, all these actions we're doing, they're in our legal capacity and not our, like, in other words, if you're gonna sue us, this is under in our capacity as
Mhm.
commissioners and not on our individual capacities. So my guess is why Gwinnett had it in there, so it's probably redundant because that's what the law would say. It's
Exactly.
fine, but it's fine.
Okay,
It's a way of sort of formalizing that all our actions as a board or, you know, you're putting on your board hat and you're taking these actions and so you get the sovereign immunity and all that comes with that.
okay, so if that's the case, then what's currently noted as subsection A that begins acting in its legal capacity would remain.
Yeah, that's fine.
Okay, and then carrying out registration and election related responsibilities as specified by state law, state and local law, that would be removed. It's not a separate section, at least in the draft, but I believe it was intended to be subsection B. But it's now been deleted.
I think it was originally A.
Okay,
And then-
right. Well, it was intended to be a separate subsection.
I
Okay,
think that the new A covers what the crossed out A was. Because it was carrying out registration and election related responsibilities. And the new A says concerning the conduct of primaries, elections, the registration of voters, and the general operation of the voter registration and elections. So it was kind of
Yeah.
redundant, which is why the old language is structured.
Right, and I think maybe the only thing to maintain some consistency would be as specified by state and local law.
I agree.
Right. Moving on, ensuring that all, elections are related activities, so. What is or was noted as subsection B, I believe, Daniel, you noted. That the one that we struck, carrying out registration, et cetera, and ensuring that all elections are related activities. Which is now the deleted B. In your note, you said these two probably could be combined into one objective that incorporates the language from 21-270 subsection A about honest and uniform conduct. Something like carrying out all registration and election related activities in a manner that complies with the letter and the spirit of the law. So, and it goes on further, but again, I hate reading to people.
I think A covers that though, right? Now, if we add that back in.
I don't believe it covers it that clearly.
Such that the primaries and elections may be honestly and efficiently and uniformly conducted. So to the extent our council has suggested this language, are we not willing to?
Well, so here's what I point about it. The reason I reworded it is because I felt like B, as it was originally drafted by Gavin or whoever it came from, it goes up, says free, impartial, fair, accurate, convenient, accessible, credible, and trustworthy.
Right.
And
Right.
like that's a lot of things that you're promising to do as a board. I'm like, if you're going to talk about your powers and responsibilities, let's just reference back. Because you've already referenced 21-270 above, if we leave that in there. And that's where I took that language was because the code says that it uses the language of honestly, efficiently, and uniformly. So I would say that covers pretty much everything you're charged to do. So that's what I was suggesting, but you really don't even have to say it because you've already referenced it in referencing 21-270. So I'm okay if you want to delete it. I was just trying to reword it to make it shorter. I don't have a problem leaving it in or taking it out. I was just trying to not make it duplicative of both what's already in. It was saying things twice in here and it was saying things that are already said in the code.
I much prefer your language over what was sorted to me.
That was just deleted is what
I
they,
mean, well, yours was deleted though.
the whole thing, they deleted the
No,
whole
I mean,
thing.
deleted
They
the whole thing.
deleted the whole thing.
Yeah.
Well, I would not have.
Well, we can talk about it. I was
I
just.
thought that's what we're
I-
doing.
It doesn't have to stay deleted, but I'm just telling you my reasoning was that in terms of simplification and not being redundant, like if we already kind of covered it and it's not necessary to say it again, we don't need it. That was my thinking.
I didn't read it as being redundant. I read it more as clarification. I think to me,
I guess they're concerned with that being the responsibility of this board, or to the extent that maybe there is the suggestion that, it's the election supervisor, like I mean, honestly,
And are we talking about the B that's crossed out or the C that's crossed out?
I think both,
Well, I think,
or even the
I
things.
think B in particular
Right,
I had taken the original A and B and said we can restate those into that language. But honestly, I'm fine with either position I'll settle on because it is a little bit redundant because not only to this extent, like 21-270 covers what I basically said there, but you're welcome to restate it. I was just suggesting combining that original A and B into one and making it shorter. So, and then when you get down to C and, that's a sort of a separate thing on education and things like that, but this is, that in terms of B, like I'm fine if y'all want to like, however y'all land on it, that's fine. You can either use the language that I did and put it back in there, or you can just delete it because it's kind of already referenced.
right, so if that's the case, that would cover what was previously A and what was previously B. What's the pleasure? Are we
I
using?
prefer Daniel's and combining A and B. I think it's just more
sounds like-
succinct to clear.
The only piece, Daniels, that's not in the way we just talked about is what's in, at least on my black and white copies in white. Basically adding at the end of the sentence that primaries and elections may be honestly, efficiently, and uniformly conducted. Because everything else in the recommended language is already what we have in it.
Right, based upon my suggestion to add as specified by state and local law, I want to say his suggested language includes federal, state, and local law, so we probably should pull that in as well. Okay. Okay, well, that gets us to page 2, or at least
What was the consensus
Well,
there?
The
Are you
consen-
putting Daniels back in or?
I think I'm just gonna tag in the line about such that,
Yeah.
the honestly, fairly and efficient. Because we're gonna add that, we're gonna add back in about the federal, state, and local law.
Yeah.
So just make that one big paragraph A state.
Right, one paragraph A, basically, and you're gonna add in the part about,
Such that the honest, efficient, audited.
right,
essentially is in his comment, beginning with consistent with applicable federal, state, and local laws such that primaries and elections may be honestly, efficiently, and uniformly conducted. So the last 2.5 lines of his comment to that, such that what's previously A will be deleted and what's currently denoted as section B stricken through will be deleted.
yes.
Okay,
It's gonna start with acting and it's gonna end with uniformly conducted.
yeah,
Yes, where we're
Yeah.
at, you got it.
understood. Okay, moving on to page 2, we're making swimming process. Section, what was some section?
Quick question, sorry.
Sure, what's going on?
Section 2, are we calling it responsibilities only, or is it
No,
responsibilities?
It's not responsibilities. I believe Daniel had noted objectives and goals based
Objective,
upon
okay.
the explanation and it was deleted.
Yes, and I mean, I said objectives and goals and it suggested that language. But it sounds like now, y'all just want to go back to the suggestion you're doing, the things that concern me with the education and the budget advocacy things, because those aren't things that are like directly in your either in 21-270 or in the local legislation. Everything else is sort of a responsibility. So if you wanted to just make it all, section 1 and section 2, or just all, all one thing.
It sounds like we should come back to the title once we've flushed out what the
What's
subsection
in
is.
that, right? And even if we have to add a different section and move some things around, I think the content is what.
Right.
Because titles aren't like legally binding.
But basically, right now, we came up with an A for section 2.
Yes,
Okay.
so moving on, if we're all good, all hearts and minds are clear. Moving on to the top of page 2, to Daniel's point about educating the public and increasing public awareness, and the rest of the language in that subsection, that's what you're suggesting, Daniel, is, or you're sharing with us, that is not a part of our codified duties as set forth in the Georgia Code.
Right.
Okay, so it's something like that that would subsequently, if the board determined, would be taken out of our powers and duties because it's not codified in the code, but would be set out as objectives and or goals. That was your point, right?
Right, and it's part of your, it's like a subpart of your, that's just not spelled out.
It's just
If you have a duty or the power to do that, it's just as part of your honest and efficient and uniform conducting, like you can educate the public and you can raise public awareness and you can, give excellent customer service, all those things are laudable and good objectives and goals. They're just not list them in their powers and duties. And so that's why I suggested basically for C and F in particular, those are two things that I would think are more objectives and goals, and then everything else is either in the 21-270 or in the local legislation.
Right, and that's what prompted my question with regard to understanding the rationale for removing some of this. Specifically using C, or what was subsection C as an example. Is it a matter of we do not believe, or in proposing the revision, is it that you don't believe that should something that is within the purview of the board, such that it's either in the purview of our election director? I'm trying to understand the rationale beyond making it more streamlined. Like if there's a substantive obligation here that
I
has
think
been to the
It
board.
was what you just said, which is, it's not the board's responsibility, it's more of the elections director's responsibility for these particular tasks.
So I'm glad that we've aligned on that, because that's what I thought it was. So item subsection C, educating the public, increasing public awareness and everything else there, it would be the position that is something that is not the board's responsibility, and that's the responsibility of the election director.
That's what I was thinking.
Is everybody in agreement? I'm not debating. I'm just trying to get us to consensus because we've got a lot of documents to go. Or,
I don't think that belongs in the bylaws. I think it's a job responsibility.
okay, so
Yeah. And I
it's,
think if we were to do anything about it, it would be a policy, not a bylaws.
okay. And again, not
That's
debating
fine.
it, just trying to understand. So are you in agreement with that, that it comes out because that's something that's ceded to the elections director? And if there's anything coming from the board, it's a part of the policy.
Yes.
Okay.
Yes, and that's how it would be.
Okay, perfect. What about you, Debbie? Such that educating the public and increasing public awareness of upcoming elections, where and how to cast votes and voter registration, ensuring voters, candidates, and the media receive excellent customer service from the Cobb County Department of Elections and voter registration is something that is not ceded to this body. And even if we did provide some type of policy direction, it would be policy direction, not be codified in bylaws.
I basically agree.
Okay.
With that. However, what I don't necessarily agree with is, possibly that should be in a policy, not in here, because I think you're committing future boards to, something that, in my opinion, shouldn't commit future boards to.
Okay, so,
Because it may be that a new board, new seated board would find it more efficient for them to be responsible at some point for education of the public or whatever. That's my,
so it sounds like we're in agreement to removing it from here. And it's just a matter of if and where we place it outside of here.
Yep.
I
Okay,
don't think it belongs in the.
in the bylaws, understood. Okay, moving on to the next item, appointing, overseeing, evaluating, and removing the director of the Cobb County Department of Elections and Registration as necessary or appropriate. Now, Daniel had a comment about this one, this section, as well as the section below that says these two items are included in the powers and duties. I would recommend them, or you could restate them as part of a list in subsection 1, but you'd probably want to closely track the language of the local law. So let's take it as a whole. The provision or the subsection that begins appointing. I see overseeing and evaluating have been removed. And that looks to have come from Stacy. The rationale for removing the board's responsibility for overseeing and evaluating the director of the office.
Well, my understanding has always been the board is responsible for the hiring and firing of the director. And so I just wanted the language that we use to reflect what my understanding was of what we do.
Okay. We've just undertaken an evaluation of the election director, and just today, Jatan, the Director of Public Services Agency, has reached out to us about that. That seems to me to presuppose that that is within the purview, and it is the expectation, and I believe it has been, definitely since I've been on the board, with respect to evaluating. Daniel, you made reference to the fact that these are a part of our powers as set out in local law. Are those two items specifically delineated or set out in local law? Overseeing and evaluating?
No, it actually just says appointing and removing.
Okay.
Well, how in the world do you remove if you haven't overseen the responsibilities of the director and evaluated her performance? I mean, I think it needs to be left in there. I think it's a little self-serving to have deleted that maybe for other purposes. I think it needs to be in there.
Yeah, and again, I didn't this came from, but that's what I would have done to say, if that's sort of what I was getting at with my comments. I would just kind of track, if you're gonna list one of your powers and duties, it can be implied in that power and duty, but the more you take a power or a duty from the law, 270 or from local law, put it in there and expand it, then you give people something to shoot at and say, well, you're going beyond, but you can always argue, well, that's implied within the language, but then if you put it in words and say, this is definitely our power and duty, now you put in writing, to say, we've taken this thing that's probably implied in hiring and firing, that you gotta oversee and you gotta, and also frankly, in your charge in the local laws is you hire a supervisor who shall administer the affairs of the board. So to the extent you've got to tell her what the affairs of the board, that's kind of like a, an oversight type thing. So
Right.
it's all sort of implied there, but I always prefer to just, when you're talking strictly only the only powers and duties, I prefer to just, and so to the extent that overlaps with that, but you could be one of those things where you could say hiring and firing is the power. And then if you're talking about in a separate section about our policy or whatever about goals and objectives, then you can list the oversight and evaluation in that policy or in a separate section about objectives and goals.
Right, which is what you had done. You had included a section that was referencing objectives and goals such that this would have fallen within the purview of that.
I
within that
think
scope.
it needs to remain because I don't know how you can hire someone without.
Well, Debbie, I guess the way I'm looking at it is, even if we write it as appointing and removing, and we don't mention overseeing and evaluating, that doesn't mean we can't. It just means it's not.
I just think there's a different motivation behind removing that, and I prefer it remain in there. And
Is the, perhaps is it perhaps a compromise to us, for us to agree to adopt a policy that speaks to that? Because there are other provisions in here that address it minimally the evaluation and some other things, because there's other proposed language that was placed in here that has been proposed to be removed around that same area. So I tend to think that we probably need a policy, even outside of this, for example. Well, we'll talk about it when we get to it, but there's other language in the same subject matter.
well, I think there needs to be clarification on oversight, right, and evaluation. Taking it out, I absolutely 100% do not agree with.
And I think my own, how I'm getting there to agreeing with this, to the extent that referencing the local legislation specifically states appointing and removing, and if that's the position that we are taking within earlier, sections of this, that what's in this document will track either the Georgia Code or local legislation, then we would accept this proposed provision. And
And to the same point of not tying other board, there have been boards that didn't participate in the evaluation process. So like,
I think that was,
That's why I said I believe it needs clarification.
I think that was
Needs.
based upon the
clarification.
conversations that I had with Dr. McMorris, and that was at a time, as well as Janina, our previous, it was, they're not participating, was that there was no formal evaluation process similar to what we undertake right now. And once that process was put into place, then yes, that was, we did, or we as a board did undertake it. But and I don't know, I mean, far be it from me to be on a board and have the in that respect, I do have to agree with Debbie. Far be it from us to be a board that has the ability to hire and fire and not undertake the tandem responsibility of evaluating and managing. But
I think that
but
has
that's
to.
laws.
I'm not suggesting that the law is not written that way. I actually just said that I was in agreement of leaving it as appointing and removing. I was addressing the fact that the statement that you made that related to what other boards have done in the past. I couldn't imagine that this board would do that, but go forward.
I do believe because of some of the controversy over it not being spelled out, it should remain there. But
Well, I
we
think
can
the
move
policy,
on. It's no surprise
I
to
disagree,
me, but
so.
I know you would, Steve. That doesn't surprise me. And it doesn't surprise me. I'm the only one taking this position. So rather than sit here and continue to hash out the same thing, let's move on.
I believe we landed that we would undertake a policy, putting a policy, and it also in doing so, I think we need to put some collars around ourselves with respect to the timing of undertaking that policy, because I'm not done.
I prefer to address that whole issue after.
Understood.
After we get through here, because I think there's,
I'm just noting it for the record,
okay.
because
Yeah.
despite the fact that the board, or I'm sorry, the director reports to us, she is still an employee of the county, and the county has a process, and we should adhere to the county process with regard to performance management, and that process is ongoing. That's the only reason I said what I said. We can continue. Moving on, determining and approving, or I'm sorry, adopting procedural rules and regulations. That was one of the sections that you made reference to, Daniel, in your comment, but it looks like specifying policies for functions. I guess the rationale in removing this, because I think what Daniel had done prior to the full-scale deletion was to remove the reference to department and make this section specific to the board. Am I right, Daniel?
So I would think I was saying with this one, you could delete them or you could restate them as part of the list up in subsection.
Okay,
The power of duty, but honestly, I think E is mostly covered in A now because it's talking about policies,
okay,
board policy, things like that. So.
all right. So then,
But so yes, originally it was just saying like, my original recommendation was just to do board, but then in our
Right.
second, in our next revision, I said, you could really just restructure these and put them up there. I think E is covered in A.
okay, got it.
So leaving it out.
Yes. For our council. Moving on, providing budget and resource oversight. And advocacy for the department to ensure that the department has sufficient operating capacity. I believe how this originally read is that Daniel had struck the word oversight and said review, such that it read providing budget and resource review and advocacy for the department to ensure that the department has sufficient operating capacity. And then it was deleted in its entirety. That's where
The
How we got to where we're at
rationale for the thing about the oversight is that you don't set your budget like the county commission
Mhm.
gets to the budget. So there's no reason you can't advocate and review what they've provided, but it's not, that's another one of those where I was like, well, that's a goal and an objective, but it's not a power that you have. So I would definitely not list that. But you can list it as like an objective or something in furtherance of your powers.
great.
Administering.
And I added this, and yes, it's similar to language that I saw elsewhere, but I also know that, we've had these conversations. We were all, well, I'll speak for myself. I was caught flat-footed when the contingency budget was presented to the Board of Commissioners and to other Cobb County leadership before it came to us. And so I would tend to think that this board would want to be aware of any modifications to the budget prior to it going to a different board, to the extent that a member of that board, say, for example, the chairwoman reached out to you, Jennifer, as her appointee and inquired about it. So understanding that we've taken the position that items that are not expressly codified in the law, whether it be state law or local legislation, would not be included here. But I think there needs to be kind of a setting or managing of expectations. And if it's in a policy somewhere, then we're not binding future boards, but it does provide the sufficient visibility that any prudent, fiscally responsible board would want to have, I would assume. So.
I'll just say my rationale for removing it was just what you said. I was just trying to align with code and just say that the duties are appointing and removing, and I would be fine with putting it in policy. Which doesn't seem like this should be codified in our bylaws.
Okay.
That's my rationale, but then their opinions.
Anyone else?
No, I mean, I agree with that.
Yeah, I agree.
Okay, so then we're striking what was subsection F. Moving on, in order to fulfill the board duties and responsibilities, the majority of the board may establish one or more committees. The board may also elect to designate one or more members of the board to serve on outside committees as representatives of the board. So yeah, this is language that I found similar to DeKalb as well as Gwinnett. Interestingly enough, the DeKalb language that we have kept in part read, in order to fulfill the board's purpose and duties, the chair may establish one or more committees with the concurrence of a majority of the board. The board may also elect to designate one or more board members to serve on outside committees. So it would be left to the purview of the majority of the board as opposed to what's here. And then I want to say in Gwinnett, it was appointments by the chair. And that is a consistent theme that I'm seeing within the proposed bylaws, removing some of the kind of responsibilities of the chair. I think that we should be drafting for process and policy, not people. And so what additional comments does anyone have on that? Are you all even using this?
I can't read that.
Oh, okay.
So, yeah,
But I have
All right.
people-
I just I pulled it up on
Yeah.
my computer.
I was just suggesting it for watching online, but I mean, that's too small for me, so. I'm just-
Right, and if I make it larger, I can't see Daniel's comments to the right, so, or all of the
I'm
contract.
fine with however you want to look at it.
Okay. So I'm just gonna stop sharing it. So where are we on this for me? So this is with respect to,
I mean, I think it's important that we should be able to establish committees, but I think that they should be established by the majority. I think in Gwinnett specifically, they lay out, I mean, I didn't like that they laid out the specific
committees, which is why I left it off.
because that was, to me, sort of onerous.
Yeah, and that's why when I,
There was a lot of committees. I was like,
right, yeah, but I mean, honestly, they're a growing county. It makes sense that they're forward looking and making certain that these, and I mean, if the committee is not necessary, it's one thing, but
Right, I
Or
mean, you
it's
should
not
have
active.
flexibility with it.
right. If they don't take up things, they just don't take up things. But yeah, you're right. I mean, the chair of the board shall appoint the chair and members of the committees unless otherwise provided. And then they have elections, full operations, technology, rules, legislative, and other committees. Those all seem appropriate. I, like you, thought that it might be a bit onerous, especially out the gate, because we don't presently have committees. So yeah, I'm perfectly fine to entertain a suggestion that this language, the only thing I would suggest is that as drafted, there's some language down in another section that speaks to election by the majority. I would align the language here in subsection C to be consistent with what is in subs in officers, section 1, Romanet B3, and shall be accomplished by nomination and election by a majority of the board. So the language is
Yeah,
consistent.
yeah.
Okay. And I will also note,
And I think the serving on outside committees was good because we needed to actually do that when, you know, we've been asked to, you know, do that with the county. in certain ways.
Where was that language you were saying needs to be inserted?
if you go to the officers section, it's something that you added. So in the officers section, so Article 4, Section 1, subsection B, Romanet 3. And shall be accomplished by nomination and election. Right. The other point I want to make is that there was also some language, I know we cribbed from, I believe it was DeKalb. There's some additional language that stated that notwithstanding that language, there is no prohibition for one, but no more than two of the board members to engage with the elections director. Do y'all remember that language? It's in that same section.
In which
I want to say it's DeKalb.
it's in the ends.
Yeah. It. Just, especially no. Definitely wasn't it. So, I mean, if we're gonna rely upon their language, might as well rely upon it full scale.
Like what we have.
Understood.
Can you tell me where you're looking? Are you looking at the committee section?
Yeah, I'm pulling it.
Tabs?
I'm pulling it up right now. Okay. All right. It was one of the other. Reach out and get. Okay, no worries. Continue, move on.
So we're good with C plus modifying it to use the same language as that other section.
That's, yeah.
And there's no other changes.
New reading again.
In order to fulfill the board duties and responsibilities. How is it gonna read?
Majority of the board may
No,
establish.
yeah, well, it's a combination of, because it's not the majority of the board, it's the majority of the board, I guess, by election, by nomination and election may establish.
What does that mean?
Well, clearly, if it's a majority of the board, we're nominating and electing. It's just a,
Daniel's language.
it's Daniel's
In
language.
another section.
Are we good with Daniel's
I
language?
mean, the board will vote to the committee.
Nominate and vote.
So, yes.
You don't necessarily have to do the nomination and election because you're just nominating people to serve on the committee and they can say they'll serve when they want. So, but you can say by nomination if you want. So
Right,
elections are for officers.
right.
Within the committee can elect their chair or whoever's gonna.
It was just trying to create some
Right.
process to the extent that we've created process in other sections, but
Well,
I think this, to me, this language makes sense in this particular location, but that's,
I guess,
I pretty much, it's pretty much what I took. I mean, I think it's pretty similar to what's in that language and language. They're all pretty similar.
Oh, no, I mean, all, yeah, well, they're not similar, in as much that in Gwinnett, the chair, creates the board and appoints the individuals that are serving on the board, so.
Sure.
And I know y'all are trying to do that, so,
I mean, I think it's really just, I mean, I hear sort of this tone and this animosity, but the truth of the matter
it's not
is,
animosity.
it should really be about a board majority determining what committees are needed. And the board majority should make those choices.
And then, and the language said in that the previous language said that it was the chair in concurrence with the board. So it's not as if the board chair would just go, whether it's me or anyone else, it's not that I was seceding to myself or that, for that matter, any future board chair, this great authority and or power, but the language reads as it does. So that's not what was happening, notwithstanding the fact that that's what's sounds like it's being suggested. That's not what it was. It was in concurrence with the board. That's what the language said.
But we're not using that.
Understood. I'm addressing Ms. Mosbacher's question or comment or statement.
Okay. I mean, yes.
That's what it said. So let's
I mean, I
be
don't see
clear
that-
about what's
I don't see
represented.
that anywhere in here. I don't know where that language is. But the only thing that's crossed out in here is that last sentence.
Oh, well,
So I
if
don't know
you,
if that was somewhere else.
well, now if you go to the section, Article 5, where this language was initially included, in order to fulfill the board duties and responsibilities, the chair, with the concurrence of a majority of the board, may establish one or more committees.
Okay.
The board may also elect to designate, so that's the language that we're referring to. So the language was deleted from Article 5 and moved up to a different section. It was just the obligations or responsibilities of the board chair and the concurrence of the majority of the board were deleted. So that's why you don't see it there. But the original language on page 5 under Article 5, do you see it now?
I do.
Okay,
I'm right there with you.
so that's what it was. It wasn't a land grab by the chair. So, but we're moving on.
So are we keeping it as it's written? So that we try-
I think that, I don't know, maybe there's a occupational bias to rely upon council to make it align with normal and standard processes. And so I thought that we said that, and he revised it to be nomination. I thought that that's where we landed.
I just wanted to make the note,
In order to fulfill the board duties and responsibilities, the majority of the board may establish by nomination, because I believe what was previously noted was by election and or nomination, one or more committees. And to his point, that elections really apply to officers and not board members or committee members. That's why he suggested nomination. Daniel, are you good with that or no?
I'm fine. I don't know.
Do you believe it's necessary?
I don't think it's necessary.
Okay, then we'll continue and move on. So. One question that I do have at the end of that is, in partnership with the elections director, establishing high-level priorities and goals for various activities under the board's purview. My initial question is, why would we take that out if it was really just a matter of things that are within the board's purview, understanding now that if it's not specifically set forth in the in local legislation, that we would not include it. So understand that that's to be deleted. All right, moving on to section 3. I believe, Daniel, you moved this down to Article 3, and then it was subsequently deleted. So this language was originally in section 3, or Article 2, section 3, and then it was moved to Article 3, section let's call it 2, board training. So Daniel, you thought it was appropriate to have it in here. You just, well, I assume you thought it was appropriate to have it in because you didn't strike it, you just moved it. And then I'm only addressing it now because it's been deleted in both places. And I think Stacy deleted this.
Where,
Right here, board training. So this was initially here, and then Daniel took it out of Article 2 and moved it here to Article 3. And then I believe Stacy, in the document you shared, it was deleted. So
my-
the rationale for
Yeah,
deleting.
my rationale was, I didn't understand why we need to have training with the bylaws, and then specifically for the Gabrielle conference. It also didn't make sense to have this Gabrielle conference in the bylaws and having to use part of the elections office budget to send a board member there.
You're not. I think the fees and travel costs of the elections director for such training shall be paid by the department in accordance with Cobb County. So we weren't paying, we've never paid
Okay.
for a board member to go there.
Because I was reading it as minimally the elections director and one member of the board.
Shall participate.
Right, so I guess.
But then the last sentence reads, fees and travel costs of the elections director for such training shall be paid by the department in accordance with Cobb County. I've attended the Gabrielle conference. I don't know whether anyone else has, but I've attended. I've never saw it. I paid my own registration. I've never saw any type of reimbursement or coverage of my cost. Or fees being the registration fee or travel costs. But I do believe it's important for board members to attend this training.
I have no problem with board members attending, I just didn't know if it needed to be in the bylaws,
Why wouldn't it be?
because then you're requiring it going forward.
Well, training is
And
kind
I
of
think
an
it's
important,
important.
training is kind of an important thing.
I mean,
Yeah.
I'm open to discussion, it's still.
Yeah, I mean,
My way, that's just my perspective.
I also think to the extent we're looking at some of our neighboring counties, and again, it's not instructive, or it's not binding, it's perhaps maybe more instructive, they include it as well. And so we look to, some of these counties' documents as, best practices. But yeah, I know DeKalb has it in theirs. I believe.
I don't know why you wouldn't want to make sure all your board members are trained.
Yeah.
Gabrielle, from what I understand, does not have a board member section. Like it's mostly designed for the actual election professionals when you were there. But what the agenda from what I've seen.
Having attended it, you're absolutely correct, but even from the election administrator's perspective, I mean, we're purporting to govern in a space that some of us haven't even been trained in. But each board member is obligated, actually,
I just don't like that.
there's an annual training requirement that's codified in section 212100. So that's probably the reason. I know we haven't referenced that section, that code, but it's actually under law.
Yeah, I'm looking at Fulton's, they have a training section.
Yeah, that's what I'm reading from right now. Each board member is obligated in cooperation with other members to ensure that at least one board member or a member of the board obtains the annual training required by state law codified in OCGA 212100. So that's probably the reason why it ended up in the bylaws, and I believe it was in our original bylaws. I don't have those. I know you have those right there. Yeah.
I think it belongs in the bylaws. The policy is a whole lot easier to change than bylaws.
I like the way.
And, excuse me, policy is much easier to change with a lot less requirements than the bylaws. And I think it's important it remains. Whether it's Gabrielle or the Secretary of State, there's an upcoming training in April. I think we all ought to be attending that training because, as well as I do, being brand new to the board, there's a whole lot we don't know. And the Secretary of State's training is board specific. But I also believe that Gabrielle, if you're overseeing an election, but you don't understand the processes of that election, how do you oversee it? So it belongs in the bylaws. Plain and simple.
How do you know where you're going, Stacy? The language in, section, or in Article 4 of Fulton, pull that over. Okay,
I just think, I like it, it's simple, and it references the code, so.
Yeah.
It's
so I think are we all in a, it's not in the current
Not
bylaw?
in the-
So is that what y'all agree?
It's, oh, here it is. Article 4, training.
So then, putting in, having training in this paragraph.
That'd be fine. I don't believe we should reference Gabrielle particularly.
It won't be, because it references the section, the code section reference. So,
I've said add Article 4 Fulton training.
okay,
Okay,
Is this what we're?
it's right, yeah, sorry, it's right there. I mean, it's an obligation, each board member is obligated. So. we should fulfill our obligations.
well, and that has a code citation, right?
Yeah, OCGA 21-2. Yeah, exactly. Mhm. So I think that then takes us to Article 4, officers.
So actually Article 3.
Oh, right, because we removed it, sorry.
Let me just ask if I can here.
Mhm.
I made a change to A. And recommended deleting the list of the, because first of all, it was only a part of the list, it was incorrect. And so I just took it out and referenced the enabling legislation.
We haven't gotten there just yet.
Right, well, that's fine, you can go ahead, I was asking if I'm reading this right, that it was put back in. So,
Oh, yeah, I'm sorry, you're right, I'm sorry. Article 3, members,
yes.
go right ahead, yep, you're absolutely right.
I was
You
saying-
want to take it out.
Well, I had recommended it being taken out, and I was just trying to see, did I mess up? And
No, no,
It may well be that I-
It was added back in.
Put it back. I just feel like that's one of the things that is important to know. As opposed to referencing back to the like, I was never given the enabling legislation, but I was given the bylaws. So I felt like that was an important piece of information to have easily accessible. If you think it's something that's going to change and we shouldn't put it in the bylaws, but that to me that's the constitution of the board. People ask that question all the time. What, how is the board made up? Who reports you? What, and referencing the enabling legislation, like it's not an easy thing to go just get your hands on.
It's not even easy for lawyers, honestly. It's-
Right, like, I
it's a
mean,
really good club.
So
But
that's why.
the reason- Let me give you my reason I pulled it out, and we can talk about how to reword it, so that maybe you can have it in there. The reason I pulled it out is because we've already had it changed at least once, maybe twice, I think. Which is why originally I think I addressed it to say that the local act as amended, and at some point we've added the language of where it was amended. But,
Okay.
so let's say that the delegation comes in a year or two and says, we're gonna change how this is appointed. Now you gotta go amend your bylaws, because that now changed it again, which you could do, but that just means like,
I'm totally fine to take it out. You've seen it change.
But the other thing is, you can't just say, it hasn't changed in my, I don't think it's changed since the late 90s, so it definitely hasn't changed in 20-something years. But if you could say as amended by so-and-so, and then colon or period, those members are currently appointed in this manner and then listed out that way. The way it read by saying one member of the board shall be appointed, this read to me like you were stating that, as an authority you had under the bylaws or something, but as long as it references back and saying like this is, so I can do that if you want to put that in there because that's the information. So I mean, both for you as board members, but also for the public to say, yeah, how do people get appointed? I'm fine for it to be in there. I just, instead of making it like a shall, like we're directing it, you can just make it more informational. So
That's good by me.
currently one member under, so I can do that. I can reword that.
I just know it's helpful, mostly because that enabling legislation is so hard to reference.
Yes, that's right.
And then I also think it's relevant because these conversations are currently ongoing. With the delegation and what's going on with them right now. And you'll recall last year, at least it was noticed in the MDJ, although I never saw the proposed legislation, but it was noticed in the MDJ that there was going to potentially be a legislation introduced that did change or proposed to change the composition. So I think that's the reason why, to Daniel's point, referencing the legislation is good. But you were saying, Mr. Bruno.
Under And I believe it's one member of the board shall be appointed the chairperson of the Cobb County Board. It should be five.
I'm gonna reword that whole thing
Yeah,
to make it just instead of saying shall, so I'll put the language.
You're gonna fix
I'll
that.
fix it.
Well, I'd say it's the Board of Commissioners.
Right.
yeah. Oh, and then, so I think that takes us through, A, Romanets 1, 2, and 3, down to B, the board shall collectively serve as the election superintendent. That's restating what's in OCGA, all the specific section reference.
Well, it's up in section 1. It says the
Right.
board has an ending charged with connecting is the power with all the powers and duties as the election superintendent. So it's already said that it's.
And to the extent we're removing, we previously removed redundant language, so I think it makes sense to remove it here.
Which thing?
It's the board shall collectively serve as the election superintendent. Daniel, I believe you said it's already provided for earlier.
I mean, unless y'all are just worried about the collectively aspect of it, but I mean, I think that's implied at the bottom, so.
So striking B.
Striking subsection B, one it's already provided for under the code. And we consistently indicated that we'll carry out our duties in consistent with the,
I was striking.
okay. And so after that, that's each member. So this is language, Daniel, that you added referencing the local enabling legislation with respect to term limits. Each board member shall be permitted to succeed himself or herself for one term following the completion of a 4-year term. Each member of the board shall have the right to resign at any time. Each member of the board shall be subject to removal. That's Daniel, that's your language, right?
Well, that's language that was for some reason done in the officers section. I'm
Okay.
not sure why. And with it being in the officers, it made it seem like it was saying like you can see yourself as an officer for following completion. I was like, no, these are the terms of being a member,
Mhm.
and you can see yourself, and those come from that 1997 amendment. And so I just moved it back up into the members section to say, look, this was down in the officers section. It's fine to say in here, it just needs to be up here in the members section and reference the law.
Okay. Do we have any concerns with it, to the point that Jennifer made earlier? Having it here informs a board member at the outset, what their obligations are and their, permitted terms and what have you, as opposed to going and finding the enabling legislation. Okay,
That's fine.
all right.
I have one question. It says each member of the board shall be permitted to succeed himself or herself. That sounds like the board member decides if they're going to have a second term,
No,
and that's not the case.
it's permissive, like
But
shall be allowed. I mean, I think if you read it in connection with the language that's just, above that, only if the delegation comes back and appoints me, I will then be permitted to succeed myself. But are we suggesting?
I'll just put after for one term, parentheses.
if we
Yeah, right. Each member of the board shall be permitted to see, and comment if reappointed to succeed himself or one. I'll put if reappointed in the appropriate spot in there. I have to read that a few times before I can figure out where exactly the right spot is, but I'll put if reappointed.
Okay.
Can I ask a question about that, Daniel?
Mhm.
Does that mean that if somebody is appointed, like, let's say you resigned in the first month, if somebody resigned and somebody was put into that seat, like a month into a term, that interim term that they're filling doesn't count, they can still serve 2 more full terms?
Yeah, and that's from the language of those local law.
Yeah, no, I just was curious if that's how
Yeah.
if I was interpreting that.
And there have been some people in that situation.
So you can serve like 11 and a half years.
I don't remember anyone doing that.
I'm saying.
Look through the list of people
Yeah.
that have been on the board in the terms. There are several that have been over 8 years. Because of that interim.
That's that.
Because they failed somebody else's, they finished somebody's term and then they can have two of their own terms.
Yes.
That's
So there's the language that was stricken, we've already addressed that above, spelling out the appointments. The board training language, we've already addressed that. Actually, I think this is the appropriate place that you moved it to. Here,
Yeah, no, board training is gonna stay in the members
in the members, okay,
section.
Okay, so that's where that's gonna.
That's where it actually belongs.
Okay.
Yeah, that was my only point in noting that.
But I'm gonna change it to the.
To article.
Yeah, it'll be, okay.
Okay,
I was thinking you're gonna make,
I'm gonna say the article 4 language from
Mhm.
Bolton's thing about training. put it
right, and put it here. Got it,
but it's gonna go here,
yes.
not here.
Okay, moving on to the officers section. Officers of the board shall be the chairperson, the vice chair, and then the secretary and the assistant secretary were stricken. I think that came from the combined input from Stacy and Jennifer.
Yeah, I was just looking at some of the other counties and they only have a chair and vice chair.
Mhm.
And again, just in terms of simplifying, I don't know that we need a secretary and assistant secretary because Debbie from Kate staff does like 99% of the minutes. And do you have any other comments about
Well, I
that?
can just say from doing it, I feel like it's almost a distraction from really being fully present. And you can go, like, we all are really responsible for the minutes when they're presented to us from the staff. And so for me, I felt like this was just an area I felt like we could simplify and make it easier to, less sort of bureaucratic on the board, but we didn't, really, we didn't need a secretary and assistant secretary. We're all going to evaluate the minutes when they come to us from the staff. That was my thought.
Can I suggest what you'll see, cities do like planning commission or something is they will have something that says the planning and zoning director will appoint a member of staff to serve as secretary, like they'll have somebody serve as secretary at the meeting for the purpose of doing that. And that's totally acceptable. And if you want to say the election director will or designee will serve as the secretary for that, something like that. I can put that kind of language in there if you want to see it and say this is head chair, vice chair, and then a separate thing in this section that says, secretary will be a member of the staff.
That makes sense
That
to
sounds
me.
reasonable.
Yeah.
Yeah, I mean, I personally haven't had any conversations with the board, with the other boards to know what they're doing. So I understand that the language is here, but do we know how they are handling, for example, this evening? We don't have a staff member with us,
I don't
so.
know how they're handling it.
Oh, okay.
But I think like Debbie can go back and watch the meeting and take the minutes. I still think that's,
Interesting.
I mean, the thing is, it's very arcane Robert's Rules of Order type stuff, but there are some roles that a secretary serves.
Sure.
Robert's Rules of Order wise, that it's helpful to have one, but it is getting, in public bodies especially, it's getting more and more handed off to sort of staff. So I'll try to put something together that y'all can look at and say, if that's.
The will of the board.
Right.
Everybody in agreement with that?
Would be disappointed. Assistant.
Terribly.
and it just seemed that the reality is that there is a very specific function, like the chair sets the agenda, runs the meeting, and the vice chair fills those roles if the chair
I
can't.
think everybody agrees, so we
Yeah.
can go.
Okay.
Okay, rather than continuing.
All right, selection of officers and terms, the chair and the vice chair, obviously, above, since we're striking assistant secretary and secretary, that'll be stricken in section B subsection, or Romanet 1. Shall be selected in the manner prescribed by law, and shall serve a term of 2 years or until his or her successor is duly appointed and qualified. I will say, and we can talk about it later, this the pronouns do cause me some pause in here, because we're not being inclusive.
We can
But,
change it to there, if that's what you're suggesting.
Yeah, that's what I say, we're not being inclusive. It doesn't apply to me, but I mean, we don't know who will come on
No,
this
I'm
board,
right.
so yeah, it was just, I thought about it earlier as I saw himself and herself earlier in the document. Officers shall be limited to one consecutive 2-year term for any one office. I think that may be 2 consecutive 2-year terms, because I don't know if it's one term, there wouldn't be an opportunity to be consecutive.
The reason I use the word consecutive is maybe this is incorrect, but I was wanting to make it clear that if a person was in one of the officer roles for 2 years and then rolled off because of the term limits, it doesn't prevent them from being reelected after they're
Just take that back to back.
not back to back. Right, that
Why
was.
not, why not back to back? I think consistency is, unless somebody's just doing a horrific job, but they still have to be elected by the majority of the board. And by what you put in there, you're removing the opportunity for the board to make that decision. Because if 4 of us think the chair is doing a good job, then I think what you did was unacceptable, quite frankly. If the majority of the board doesn't think so, then they have the right to vote that chair out. And you're limiting it because why?
That's true. But I really took this idea from Cobb Board of Education, because they do not allow a chair to serve more than 1 year.
I think we're totally a different makeup than the Board of Education. And, you know, the Board of Education needs to know Robert's Rule of Order, basically. The learning curve on the election board is significant. And I am adamant that that not be restricted. That should be in the authority of the majority of the board.
So Debbie, this wasn't my idea, and I didn't even think about it until I saw Steve's comment, but I actually like it, and I'll tell you why. I think it helps us with succession planning. Because if someone stays board chair, let's say for 8 years, then when that person rolls off, there's not going to be another board member who would have any experience running things.
I'm not going to buy that, but okay. I appreciate your
I mean,
opinion.
you don't have to buy it. I'm just saying that
Yeah,
I like the idea of having multiple people in experiencing different roles, because if you have one person with all the experience and they go, then we're left with a lot.
we also might have board members that have no experience and will suck as board members, I mean, a chair. So I participated in different situations like that, and, you know, I'm really, really adamantly opposed to this.
I don't know what Tori and Jen think about that.
I'm happy to defer. You've made it about the chair. But yeah, I see both sides of it. I mean, I'm hoping that I wasn't a board chair that joined with no experience on the board right into the chair position and didn't suck. Hopefully that's not the case here. But officers shall be limited to one consecutive 2-year term for any one office. I understand the rationale. I don't believe the language works. I think whatever we align on, this doesn't work, because you can't really have one consecutive 2-year, you know, for something to be consecutive, you gotta have more than one. So the language needs to be fixed. I see both sides of it. Yeah, I do
Well, you
believe.
could do what Gwinnett does and require, this should just totally drive you over the edge. Gwinnett every 2 years flips parties on who is appointed chair. Why don't we do that?
Been there.
That would be a great idea. Let's do that. Since we're borrowing these bylaws from all these counties, we can look that up. And I could get behind that, Steve.
After we've done what we have for 45 years.
Yeah.
So it's even, then it's time to.
Well, I don't know that it's a matter of parity even, because I consistently say voting is nonpartisan. And it shouldn't be. Who you vote for is partisan, but the work of this board, it really should be
That
nonpartisan.
I agree, but that is Gwynette's role. They.
I understand.
Yeah, what do you see, or how do you?
If it- I'm going to decline to wade into the, if you want, if you
What
want.
happens in other boards? I mean, this is just curious in terms of, like, is the chair often elected? Is it like ours is on a 2-year
The boards that
cycle?
I work with, it's just up to, there's no like, but council councils term limited themselves. So that's a way of doing it, like Marietta put term limits in on themselves. So it happens, but planning commission and. I mean, but they're all different. Those are different. There's people coming in from different districts. They're recommending things on. Zoning items, and so they just have a. You know, I've been through the changes to bylaws that I've dealt with, those levels have been. The way people are elected or vote like that. Do they do it by nomination or do they're going to have to tell them you can't do secret ballot? I know that's in your bylaws, but that's not what they. The government. That's. That's what I've dealt with, just in terms of it's fine either way. There's nothing saying there are absolutely benefits to having, long-term people serve and that have experience. There's also benefits of saying like, let's roll some people through so you have multiple perspectives and multiple. What is odd about this board is I will say at almost every other board, usually, this is credit to Cory, but usually the chair has to miss a meeting or two and you have the vice chair who gets some experience. So like they might be the next natural person to serve or something like that. So there ends up being more of a seniority thing where the vice chair then usually when the chair rolls off, the vice chair would be the chair. But that's just, there's nothing in the bylaws to require any of that. That's just kind of how it works. And so predatory for literally being in every meeting, but the vice chair doesn't usually have to.
Except for the next 5 months.
To run very much. So anyway, so that's, this is all totally, I can help you with the language if you settle on how you want to do it, but most of the boards that I work with, it's just too bad. The board wants to pick.
And I guess the only distinction I would draw to the Board of Education, they are elected to represent a particular district. Whereas we represent the entirety, like it's a different governance structure. It's a different, process by which they serve, come to serve on the board. And, I don't have, or you don't have, or any of us don't, we don't have a particular group of, Cobb voters or constituents such that, the person needs to change to be certain that that voice is there. And so that would be my distinction in the analogizing it, this role or, the roles that we have to the Board of Education. Because we don't represent, any constituents of a particular, BOE district. We should be working on behalf of all.
Do we want to? Vote particular one, do we want to take a straw poll and see what the majority feels?
I would just go down the line and say I would leave it or I would want to do this. If the consensus is you want to limit the, or make it more of a limit on who can serve in terms of how to come up with that, but if you want to just strike it, so maybe just go down the line. I mean, we'll start here because this is easy. There says out.
Totally. 100%.
No, we're just talking about that line.
Yeah, the line, just the one.
So
So,
if we try to keep it how we word it, so don't worry about the wording, it's more.
Right. So Jennifer, in or out, the highlighted language.
On the line. We're going down the line, Dan.
I just started because I was on the top one.
Generally, this is how I always go to the right.
I'm calling. Down the line.
Well, I'm just starting with the people that I know.
Right.
Steve, Steve, once
He's
again.
not, he actually doesn't, he doesn't,
Down the line, it's down the line.
actually, I preside over this and I have always gone to the right and then come back here. So we can make it about this if we choose to, but that's not what's presently
I
going
don't have
on.
any opinion right this second.
Okay, then that's your, that's your statement.
Okay.
Have I not come to the right and gone to the left? That's what I've done all evening.
I'll just go ahead and.
Go right ahead,
I'll
Stacy.
say-
And you, you'll keep it in. Yeah, I would vote to take it out and you're voting to take it out.
I'm
Jen?
voting to take it out
Okay.
because I think there's some motivation involved with it from other sources that I highly am offended by. So, okay. Just saying, let's move on.
Well, we have a tiebreaker.
Now I, yeah,
She's not said she wasn't
She typically got
prepared to
it.
answer.
okay.
I'm gonna think on it is, well, actually, I'm just gonna make a decision. I think that we should take that line out. I think it limits the board. And I think that if we're being consistent with all these other things, I just think that limits if people really want somebody to serve another term.
Okay,
All right.
All right, majority says L.
Moving on, the officers shall be elected. I think this language was fine. It just removed the reference.
That is the law.
I don't believe there is any
Can you read it?
changing of the law. It says the officer shall be elected at the regular July meeting. The language that was added in the applicable or in the odd numbered years, I think we should just make that odd numbered years unless otherwise necessary. I don't know that there is any substantive,
It was just
Change.
clarifying.
yeah, it was clarified, like it wasn't going to be in violation of the law.
I think I added it.
I don't know which one. I just was like, whatever was there was confusing to me. I like it how it says odd numbered years because that is
Right.
exactly what it is.
And I think it's just a matter where it reads odd number. I think it should read odd numbered.
Yeah, number.
Yeah, and
Exactly.
yeah, and that was it. All right. Selection of officers is solely within the discretion and shall be accomplished by nomination and election by a majority of the board. That was language that Daniel added, the same language that we referenced earlier with respect to committees.
Correct. And I'm just doing that because this is really, when I think of bylaws, this is one of the main functions of bylaws is to say, well, how do we do it? Because you can say it's by discretion of the majority of the board. What does that mean? Do we just, how do we get there? And so that's, I'm just telling the most basic Robert's rules form of nomination election. And so that's what's recited. So that was my recommendation. So the future boards don't look at this and go this, why do we do it this way?
All right.
About
Okay. So that was the language that you had taken up to the member section, right, at Romanettes 4 and 5. Okay. So we've already addressed this in article. So moving on to officer duties, the chair shall convene and preside over all board meetings and shall call special meetings when necessary and advisable. That's consistent with Robert's Rules of Order. Shall approve the agenda for board meetings. That again is consistent with Robert's Rules of Order. However, everyone approves the agenda. Moving on, I believe these were items that you'd stricken, Steve. Steve's draft suggested deleting these items. I've left them in, but inserted this comment that said you can discuss them, and I think Stacy came back and deleted them. But he only deleted C, D, and E. I do not believe that he deleted F.
That's correct.
Okay, so, and that's the only reason why I'm drawing that distinction so that it gets attributed, those were the ones attributed to you. So the board chair shall work in partnership with the elections director to ensure the board directives and policies are carried out, shall serve as spokesperson for the board in accordance with board policies and directives, and shall convey the board's policies and directors to the director and shall coordinate the election director's annual performance evaluation. If I might, given the interest of time, E shall coordinate the elections director annual performance and evaluation. We've already talked about creating a policy that speaks to the board's assessment or performance evaluation for the directors. Can we agree that we would move E to that policy?
Yeah, agreed.
Okay, so quick work. Now it's yours. The floor is yours.
I basically focused on the current bylaws.
Mhm.
Bylaws A and B. And C, D, and E are not in the current bylaws. I oppose expanding chair's bylaw responsibility. The board can ask the chair to do any task that needs to be done. But I'm opposed to expanding the chair's duties and responsibilities.
Great. Anyone else want to weigh in?
I mean, I agree with Steve's philosophy, because Danielle's kind of ingrained in our heads that every board member is equal except for the chair who runs the meeting and sets the agenda. So I just, that's how I've understood the chair role, so I just wanted to like that in the bylaws. So I agree with his revision.
Mhm. Anyone else?
I don't.
Agree. Well, I will, I'm sorry, and do you have anything to add?
I agree with it just being A and B.
As we have with a number of the provisions we cribbed, if you will, from other counties, and the language comes from DeKalb. And I know we've looked to DeKalb or their particular bylaws for some potential guidance. Again, it's instructive, it's not binding, but I think that's the reason why. And then, I mean, we can just be very transparent and frank as it relates to the conversations that we've had among these, or, you know, the five of us with regard to working in partnership with the director, serving as a spokesperson. I know that it's traditionally been the chair, and I think if there is not, and maybe it's a policy, but I think in the absence of someone that sits in the seat, whether it's myself or anyone else being the spokesperson, maybe that needs to be put in a communications policy. It could be a free for all.
I think it needs to remain in the bylaws.
It's not in the bylaws right now.
This, what we're redoing right now, I think it needs to be clarified in there. Because in most boards that I'm familiar with, the chair is the standard spokesperson for the entire board. The entire board elected the chair to do their job. And so that's, in my opinion, a vote of confidence. And you have to have someone that is the point person on that. And to make it any different, I think is.
But we've existed for 45 years and not had that.
It's probably not being questioned.
Well,
Okay, that's, I'm gonna guess, and based on, and I don't think you want me to really voice my opinion on why it's even in there. So I won't, but I've never seen a board that I prefer that Chair Cupid would not be the spokesperson for Cobb County. But I agree that she should be. I mean, I just find it very.
but she's elected.
I don't care. So is the chair by the individual board members through a vote. So I think there's personal opinions going into this particular portion of the amendments, and I, again, don't appreciate it.
So Debbie, just, I know you made that comment a few times. I
Yeah.
know that's your opinion. I mean, in 2 years, none of us might be on this board. In a few months, you and I might be the only ones out of the group at this table on this board.
Yeah,
So I am thinking about it in a way is, this does not necessarily impact five of us as much as it impacts future boards. So,
I understand.
I'm.
I
thinking of
totally
it as,
understand.
how do we think the board should operate for the future, not necessarily for the next few months?
My opinion stands whether it's now or for the future.
Right.
And I think opinions are being made without regard to ongoing boards. So my opinion, your opinion,
Yeah.
their opinions.
I think it's time to do what we did earlier. Go down the line, and I'm gonna start this way, so we could go different ways.
I again was clear.
Okay.
Okay.
I am fine with taking it out, and the reason why I'm fine with taking it out is because we have taken the position that things are codified, if you will, and while there is no code that speaks to this, there is kind of a Robert's Rules of Order but that we can analogize to the code. So I'm fine with taking out. However, I do suggest, having sat in the seat for the period of time that I have, that there be some type of policy. Because in the absence of a policy, especially as it relates to being a spokesperson for the board, in accordance with the board's policies and directives, like, it's a free-for-all. And we've had these very conversations, no shade, Debbie. There have been commentary around the number of emails and the different questions and the different asks and requests that Debbie sends to our director. And so I would just, to your point, for future boards, perhaps, again, this is one of the areas that we manage with policy. And you, Mr. Vernon?
I would take out
Of course. And you?
E, D, F.
We didn't talk about F, we were only talking about D and E. You said F wasn't among what you provided. So I'm sorry to interrupt, but I'm just saying.
I think we're
But
just, I think we're just talking about.
we already talked about E, we were gonna push, exactly,
B and D.
C and D.
Okay.
Right, he said F, so I was just inquiring about F.
Sorry,
Okay,
it's hard to read.
understood,
I'm excited.
yeah,
I will say out for C and D.
okay, and,
Out for C and D.
okay, so Daniel, C and D are out, E goes to a policy. F. The chair may vote on any matter presented to board members, but shall not be authorized to present a main motion at a meeting of the board. That was not deleted by Steve. It did come from the joint contribution from Stacy and Joe.
Yeah, my rationale was just for consistency to keep it as the chair has the A and the responsibilities laid out in A and B, and in all other functions, everybody is an equal board member.
I believe that comes from Robert's Rules of Order with respect to making a main motion.
Yeah, it's in Robert's rules. Honestly, you don't have to follow Robert's rules. Honestly, but I would not recommend putting F in there. What I would actually put in is the opposite. My recommendation would just say to allow the chair to vote to make a main motion, because there's just sometimes when, you can get kind of stuck. Somebody's kind of, like, I don't know if I want to make a motion on the chair. I've never seen any real. And to me, it makes sense when you have like a mayor that's serving as the chair, and like you want to make sure the council people are doing it. But when you have 5 board members who ought to be able to, make motions in seconds and vote. But it is traditionally right.
Right.
Under Robert's rules, that's a very standard thing, is that the chair doesn't make motions and you defer to everybody else. But there's times when somebody doesn't make a motion, either 2 people or, you might have 2 people who have to abstain, or one person's missing, and then you got a motion that's not going to pass, but somebody doesn't want to make it, so you got to have the chair. So my recommendation, just from pure convenience standpoint, not doing legal about it, is just I would just like to say that I'm fine for the chair to be able to make a motion. So
And I think it was to make a main motion, make it second. And then, but it was just to make a main motion. But again, it was consistent with what's in Robert's Rules of Order. So We may need to the extent that the language reads. How does it read here? Unless otherwise specified. Yeah, to the extent that they are not inconsistent or do not otherwise, okay. So yeah, unless otherwise specified, Robert's Rules of Order. Okay,
But now, if it's not in there, the first Robert's Rules of Order, which actually kind of says what F says.
Mhm.
If you want to address it, you could address it and say that you can vote. The chair to be able to make a vote.
Well, to the extent that the language is shall convene, shall approve, the language could read shall be permitted to present a main motion,
Maybe,
may.
rather than shall.
No, she shall be permitted, doesn't mean that you have to, but yeah.
Permitted.
Oh, I'm sorry.
If we don't say anything, is it just assumed that the chair can make motions?
No,
because
because
Robert's rules
Robert's
say no.
orders in the
Okay, so if we want that.
that's why I said shall be permitted.
Okay.
Yeah.
That's correct.
So the language that I provided, was that good?
Yeah, that'll work.
Oh.
If y'all want to give the power, I can just include it.
Okay.
Just say basically, it would be what Tori said, but it would be may vote and shall be, reading proceed. What I would say is that shall be authorized to present and vote.
I'm good with that. Yeah. So then based upon the earlier revisions, Romanets, what was Romanet? It looked like 2 and 3 will come out, but it's the duties of the secretary and assistant secretary. Looking at Article 4, this was previously the language about committees of the board, but it's been taken up to another area or another section in the bylaws. That brings us to Article 5, political activities.
Can we have a little break
Of course,
for a minute?
I'm sorry, I'm just.
That's okay. I need to go pop a couple of aspirin myself.
Do we need to make a motion to adjourn, to recess, Daniel?
I would, well, the chair can just say.
Yeah, the meeting's recessed.
Okay, and then do we need to do something there?
Yeah, we recessed at 9:08 p.m.
Just pause the.
Let's mute it.
to mute it. Perfect. We're at a recess at 9:18, so we took a 10-minute recess. All right, moving on to the next item, Article 5. We'll just call it Article 5. I think that's the right, but the heading is political activities. And these are codified, this language is codified and in the relevant section references to OCGA are noted. So I guess at a high level, does anyone have any concerns with including this language? Which again restates and references provisions from the Georgia Code. We've done that in other areas in these bylaws. Does anyone have an objection to this? No. Okay. So we'll leave that language in. Moving on to Article, I guess, 6. The numbering's a bit off on mine. Regular meetings. I know that there was a preference here not to commit other boards, as we previously noted, on second Monday of each month, such that the language now reads the board shall hold a regular meeting at least once a month at a time, date, and place to be determined from time to time by the board as evidenced by a majority vote of the board. And that seems to me to be reasonable. Are we all in agreement that the language stays in as drafted? Okay, moving on, section 2, because we now have other meetings. We've got our election day meeting, our pre-cert meeting, and our certification meeting. And on the days of primaries or elections, this one's messy. I think we can all agree that the election night meeting
Here's what I,
will be held at the close of polls.
so I would just say on the day of the primaries and elections, comma, the board shall meet
The
at the
board.
close of- at the close of polls
Mhm.
to commence the computation and canvassing of the returns. And that's straight from the statute, the whole
Mhm.
oversee election returns. I mean, I guess that sort of gets at it, but that's what the statute says. Is that
Right.
you're this meeting tonight, technically,
Mhm.
to commence the computation and canvassing of the returns. So that's why, and that I took out the 7 because like if we have like some sort of mass shutdown or something, we have some
Right.
that takes place in them, just say at the close of polls. So that's, I can fix that language in the beginning that's weird about conducted by, I think it was just because there were so many edits made that it.
Right.
I'll fix that.
And you can make that Romanet 1 because that's language that only refers to election day. And then you can have Romanet 2 that makes reference to the pre-certification meeting. And then,
Pre-certification is only required by a rule, right? Not a law.
well, after this legislative session, it could change, but that you're correct. The board shall hold a pre-certification and for such other meetings as may be required by law or as necessary upon the call of the chair.
Is there a way to make that so that it's just kind of generic covers? Like, do we need to say pre-certification meeting or can we just say other meetings?
Well, so the only 2 that are required by law are the first 2. So the board shall hold a meeting on a date and time. So that's, put that as number 2. But that's the certification meeting.
Election day and certification are required.
Yeah.
Well,
The SEB now requires a pre-cert meeting. And so I was lumping that in with like the other, because the election and the certification meetings are pretty much mandated, but the pre-cert meeting and then other special meetings are on whatever day, and during either whatever window you need to hold it, like for the pre-cert, you got to hold it before. You don't have to hold it on Friday, but you have to hold it before certification. So you could pick to do it on Thursday if everybody wants to be.
I thought the rule did specifically state
It said
Friday
Friday
prior
to 3 p.m.
Okay, does it say on Friday?
Yes, that's Friday prior to 3 p.m.
I don't know if that was my.
But that could be amended or.
Right, but that was my thinking, it's an SEB rule, so I hate setting bylaws based on an SEB rule, but that's why I just kind of made them more generally as required by law or as necessary on the call of the chair, so.
Well, then I would suggest we strike as required by law because it isn't required by law, it's required by rule, right?
But I thought that was language was also to encompass the certification.
Yeah.
Can we
Meaning,
have a paragraph that's just for the what's required by law, that's election day and certification? And then,
so Romanet 1 could be that.
Would special meetings include pre-certification, or is that not considered a special meeting?
No, it's not. It's right now, it's a regular meeting because you have to have, you're required by regulation to have it.
Right. Well, I mean, and usually, I mean, I've seen language as required by law, rule, right, regulation or other governing.
That would.
Yeah, I think that would be
More clarifying.
right.
Frankly, I wish we need to go back and see if one of these SCB suits challenging, because I honestly think the pre-cert meeting is outside of.
No, that is the only one they
Yeah.
did challenge, and the Secretary of State did put out a official statement that the meeting must be held.
Right.
And I see Ms. Riddle is agreeing with me, so we should go with this.
No. I think that one, go, but that's fine. It is what it is. And I also think it's silly to do it for like, we have to do it for a special primary.
Yeah.
Like why? But okay.
So my notes here say Daniel's gonna edit this paragraph. Is there anything?
you're gonna make that paragraph
Yes.
fly with the law slash rule.
And make it clear. We'll say that. Yes.
Okay.
So
That's gonna-
substant, like we are in agreement substantively, the language, we'll just look to Daniel, but we're in agreement
Yes.
because it's required by law. Okay,
And then it will include election day certification and then also pre-certification as required by rule, or are you gonna just say other meetings as required by?
I'll probably, when I'm drafting it, I'll probably do election day certification and pre-cert, and then the board, then have another one that says, because see, we have a special meetings one right there.
Mhm.
And so I think I was trying to say like, well, right now, the only one that's extra is pre-cert, but maybe it's the SCB requires other, another, like, so I'll clean it up. I'll probably just get rid of that as, I'll just make a pre-cert entry and then we'll use that special meetings for the other meetings as necessary.
Okay. And then to the extent that, again, the pre-cert is not required by law, although it is required by SEB rule,
Regulation.
we'll just, law, rule, regulation.
Which would cover you if they retract it,
Exactly.
right?
I believe so.
Yeah,
Or if it becomes law.
or if it becomes law.
During the
then you're
legislative
covered.
session,
That's
yeah.
correct.
Okay. So then I think we're good there. Going to section 3, special meetings. Special meetings may be called as necessary by the chair or a minimum of 3 members of the board with proper notice published pursuant to OCGA 5141. Reasonable prior notice shall also be given to each member of the board prior to scheduling. Are we good with this language?
Sounds okay to me.
I,
Are you trying to come up with some minimum notice period?
yes, I was thinking of a timeline on proper notice to the board, but also with a stated reason for the meeting, maybe should be added in there somewhere.
Right.
So it's held to only a special purpose rather than,
So 5014-1 talks about that
It
if you're
does.
calling it and it's not a regular meeting, that's why I referenced it, because it talks about you have to publish the reason for the meeting with the notice of the
Okay.
meeting.
Right.
well,
I mean-
inconsistency, we've kind of clarified the law in other segments that would
I'm fine. I feel like-
that would call that out.
I'll look at the language and see if there's something I borrowed from 5014-1 that says,
Okay.
with the notice, the reason for the meeting published.
And
Yeah,
I definitely understand this. I don't believe it would be prudent for any chair to call a meeting without, confirming with the board that they are available. I think it goes without saying. But, obviously not saying it may empower some future board chair to be in a position where they do call it. So that makes perfect sense. But
The only reason I'm thinking about adding, for the,
the purpose of the
Purpose
special
of-
call meeting.
so that you can't pile on, you can't amend the agenda and say, oh, we want to talk about 3 other things, et cetera, et cetera. Because then to me, that needs to be deferred to a regular meeting, especially with the controversial emails going back and forth today on allowing public comment during a, special call meeting.
Oh, we're getting to that.
Okay, well, I just want to throw that out there because I don't agree with it. If it's something that the public should, it needs to be done in public with public comment. So I'm not going to start amending this again, God forbid, but I'm just throwing it out
Understood, and I think we'll get,
there. Okay,
we're getting there to the public comment.
And we're just gonna add some sort of clarifying, spell out a little bit that a special call meeting has to be stated purpose.
that's consistent with what we've done.
Okay. Section 4 quorum, that is just language that was taken from section 5 and moved up to section 4. So I presume we are fine with that. Because it,
It
again,
seems to make sense since we're talking about a minimum of 3 people in the state sentence above it, that quorum was defined somewhere. I don't know the right place for it, but.
yeah, it was defined. We just, again, I've just noted that it's not net new language. It was just taken from somewhere else in the, or in the bylaws. So we're fine with that. Okay, everybody.
Yeah.
Hearts and minds clear, okay. Board meeting agenda, the elections director shall solicit items for discussion for board members, including matters the elections director deems necessary for consideration of the board. And then the agenda shall be approved by the chair and provided to board members no less than. So we already talked through this, or for that matter, voted that we would provide or at least publish the board meeting agenda 7 days prior to the board meeting. I believe we're fine with this language.
I just don't think we can, I personally don't think we can commit to that in our bylaws. I think we would end up violating that because it just can't happen all the time. Like, an agenda is not always gonna be published 7 days before.
Right, I think
be a policy
initially
that
it
we
was, I think it was initially 3 business days and then. I mean, whatever one want to do is fine. Like I said, I mean, if it's provided for here, if we don't want it to be here, we can take it up. So it sounds like Jennifer does not want to commit to any time frame, 3 or 7, or is it just 7?
No, I don't think we should.
Commit to any time frame?
I don't think we should do it in the bylaws.
Okay,
I'm fine with that. If we want to make it policy, we can do that. I think
okay. We did, that's my point, like, so this is coming out anyway.
I'm fine with it not being in the bylaws.
Okay, so then the language as noted there, the revision of executive to elections director needs to be changed there. If it's changed on your end, and then honestly, I think the same probably is applicable to the structure of the agenda, like what, that's not something, it's not codified in law. And that's been kind of our governing principle around what we leave in the bylaw. So that would just come out. Okay. And it looks like public posting, that's actually what we voted on, apologies. Not less than 48. So we're just gonna leave this language out. Agendas for monthly meetings shall be made publicly available in accordance with applicable Georgia law. I think we should strike the word monthly. Because it seems to presuppose that that's our regular meeting. We are required to publicly post any agendas for meetings held by the board. So I would include that. Such posting shall include all supplemental materials not deemed privileged by the board's legal counsel. When necessary, posted agendas may be amended prior to the meeting or during the meeting. That gives us flexibility we need. Any objections? No? Okay. Minutes of all meetings be taken in and made available for inspection in accordance with law. I don't think that there was any proposed revisions there. We already talked about section 4 quorum, it was moved up. Board action. Action and decision by the board shall be permitted during a notice meeting by a majority vote of the members present and participating. Yes.
A notice
I've already circled that.
meeting, not meetings.
Yeah, I've already circled that.
Okay.
Okay. I just wanted to seem like I was a smart person.
You're paying attention. Sure.
So I guess I had a quick question about the first sentence, present and participating. The need for and participating, I'm hopeful that if someone is present, they're participating. But yeah, I'm just gonna find some humor here somewhere, but yeah.
I think the reason that's there is occasionally a board member does zoom in. Just saying. And they would not be present if there be via Zoom when, like when Stacy was in Europe or wherever she was, and where Israel.
Yeah, but that covers present. I was questioning the and participating portion.
So the participating is this, well, for one, it could just be, I need to step out of the restroom.
Okay,
And so, you know, you can, if for longer meetings like this, you don't have to recess, you can just say, hey, I gotta go. Or
Mhm.
if for long council meetings, you'll have people go get a snack and come back, and if they're not interested in that item, they don't vote on it. So legislative session, like, people don't show up for votes. And so that's one thing. There's other times when I'll say, you know, hey, my cousin's running in this race, I'm not gonna participate in whatever, so you're abstaining. So that's why the participating is not in terms of like, I'm not engaged and I'm not participating, meaning like, I'm either abstaining or I'm out of the room. Because I
Okay.
need to-
So you're saying we should keep the word participating?
Mhm.
Because let's say there's 5 of you up there, one of you leaves or has to abstain, then it would need to then be a majority of the 4 that are remaining.
Okay. The language, Stacy struck the language maintaining a written record of policy decisions in lieu of something later. Posted in policies on Cobb County's website upon approval. I agree with that.
It just seemed a written record was like.
Well, that's what they,
Antiquated.
well, and that's what they did, because it's in that little blue deal and it's, you know, on January 1st of 1908, this is what they did. Sorry, I'm tired. But we're gonna continue to move on, but I think we're all in agreement. Okay,
So it's good
as drafted, yeah. All right, public meetings, public comment. We're just gonna go permission by permission. If y'all, there were no red lines there, so I thought it was fine.
Yeah.
Oh, okay. Yeah, I will inquire, yeah. I just kind of adopted this process that there were no proposed revisions, but I will inquire even in the absence of no proposed revisions. Public meetings, public comment. All meetings shall be open to the public. Public comment shall occur at regularly scheduled monthly meetings. This is the point that Debbie raised. And admittedly, I raised it in our email exchange. So something like public comment as provided for in the bylaws. One, is this something that needs to be provided for in the bylaws if we're undertaking the premise that we're only going to be including sections that reference things that are codified in law?
Well, it is codified in law. It's called the First Amendment. And it's about as high as it gets.
Okay.
And I think to have major discussions without allowing public comment is never a good idea.
So,
We've typically not, as a board, we have not had public comment at special call meetings. Correct, Daniel? Like that's allowed, like when we've had special call meetings, like if it's,
You're allowed to not have public comment, yes.
yes.
Most boards, at any level, if they're a board that takes public comment, council or commission,
Mhm.
yeah, honestly, you guys are rare. I mean, most election boards do it, but y'all are a rare kind of board that's not a county commission or a council that actually takes public comment. And it's important because of the subject matter. And so, but for those that do, that it's usually they may have 4 meetings a month and they're allowed at 1 or 2, and then, and that's it. And you don't get public comment at the agenda work sessions, and you don't get a special call or for a special purpose. You're doing it for that. And even I would, in this case, like an election meeting, I was a little surprised to see public comment on, but I understand you're allowed to do it, and you can do it on a case by case basis if you want to. There's nothing saying you can't do it. But generally, if the meeting is for a specific purpose, rather than instead of just being your regular monthly meeting, then you want to try to keep it to that, but you're allowed to add it. I would not, this is totally up to y'all whether you want to make it bylaws or policy. There's nothing.
Well, I think it's not just the Constitution, the First Amendment. There is a Georgia, and correct me if I'm wrong, there's a specific law that allows for public comment under Georgia law, correct?
Open meetings.
Well, I don't know about public
Comment, okay.
comment. I mean, it's just that you don't have to, you can have a board that doesn't have to
Okay.
public comment, but
Well, just trying to align with the way that we've approached things thus far.
right.
Maybe-
I'd have to go look.
Okay.
I haven't looked into the public comment issue, other than the issue about the,
Well, minimally, all meetings shall be open to the public. That portion is codified in Georgia law.
I
Okay.
was actually gonna suggest we need to break out A, and I
Yeah.
have a standard statement that we make. I'm gonna make all meetings shall be open to the public and use the language that says it shall be conducted in accordance with the open meetings.
Okay, so yeah, bifurcating the two,
And then put public comment in its own section if y'all wanna do that, or you can make it a policy.
right. And I think it might need to be a policy that allows us to kick the can down the road as it relates to having public comment at regular scheduled monthly meetings, given the hour. Also the varying opinions, that are on it. And, I'm happy to share my opinion. It's what I've shared in our email communication. Yes, Steve, you raised the point that public comment does not necessarily happen at election night meetings, but we also don't generally undertake the business such as this, such as a vote on an AIP policy. Schedule that allowed Sally to come in. Like we have not generally undertaken substantive business at an election night meeting. And if we are going to adopt that policy, public comment should only take place at regular meetings. I think we just have to be very intentional and thoughtful about the items that we put on meetings, like the agenda for meetings like this evening.
I personally believe that we have one job to do tonight and we aren't doing it.
Yeah.
I would not have done this on election night, but, just saying.
We all agree with that.
Yeah, we all did, and I found the email and I think I brought it with me if you want me to read my objection.
I suggested it.
You did,
I'm sorry.
All good.
okay.
So I guess all meetings shall be open to the public. That's consistent with the law. Public comment, policy, can we kick that, or public comment, can we kick that to a policy? Or do we believe that it needs to be included here?
I don't think it needs to be.
I'm okay with it. I think it needs to be somewhere, and I'm fine with it being a policy.
Okay, so yes. Yes.
Maybe somebody here can draft
A
a policy
policy.
for the meeting.
They're actually, perhaps we look to the BOC, they have I've looked in their policies, all of their policies, and they do have a public comment policy. Perhaps we use that as the basis to move forward. Obviously, it's not going to be exactly the same. So all of what's present here would be kicked out. Okay, so then that takes us through the second sentence in subsection A, subsections B, C,
Really don't look at it, so
yeah, all the balance of Article 7.
I think all the way down to our, so that gets us to rows.
Oh, yeah, okay. Subsection, okay, gotcha. Article 7. Oh, I don't know.
Looks like theories.
Yeah.
All right, go ahead.
Employees, physical facilities, I'm fairly certain this language was,
Strike everything.
no, we didn't strike any. Well, yeah, we struck it such that the only thing that's in section 8 public meetings is the first sentence in subsection A, all meetings shall be open to the public. The balance of that relates to public comment, and I thought we agreed that we would
Yes.
kick it to a policy.
We did.
Okay. So the sections A, the final sentence, second sentence in section A, subsections B and C. And then the language that is below Romanet 6 is kind of duplicative of what's above, but again, it relates to public comment. So that would be in a policy. Moving on to employees, physical facilities. I believe this language is in the original draft of the, here it is. Yes, so section 6 on, at least for me, is page 4 of the original bylaws provides for employees and physical facilities. So providing context as to why the language is here. The language that was stricken was taken directly from the previous A Romanet 1. That language that was stricken was taken from the previous version of the bylaws.
The top part is, that is what is in the bylaws.
Right.
Yeah.
Yeah. So then that would just remain. Daniel,
Yeah.
okay. So we're fine with the board shall obviously employ a full-time elections director at a salary to be fixed by the Board of Commissioners of Cobb County to administer and supervise the conduct of elections and primaries and registration of electors of Cobb County pursuant to duly adopted resolutions. And then Romanet 2. The board hereby delegates the powers and duties of the superintendent and board of registrars as provided in OCGA. Does anyone have any objections to what's set forth in? Okay. Daniel, you didn't redline any of this.
I didn't redline any of it, but it was kind of one of the ones that, it's Jennifer, it's up. Stacey, is that your language you added? Or was that delegated?
Delegates of powers and duties.
I don't remember it being in there.
It's not.
It's not in the original.
It's not. Well, that's what
Yeah.
I thought you were referring to the original.
And was it in yours?
I think we put that in there, just to explicitly say that we're the election superintendent, and then we hire the elections director to run everything for us. So we're delegating that power to our elected director, which
I'm not super, I would want to clean that up. You can,
I'm pretty sure we took it from a different.
yeah.
Yeah, I was just looking.
Other counties might use that language.
Right.
Some of them,
I don't think we can delegate.
right.
Isn't that what we are doing though? Maybe?
You're delegating the administration of the elections. But you can't give her the power and duties. Like
We have
you
to
have
be
a
setting-
superintendent. But I can offer some language that like,
Okay.
that tracks the language of the local law. I'll clean it up.
All right, so then that takes us through subsection 2 or Romanet 2. Elections director shall be responsible for, so we're in Romanet 3. Spells out the responsibilities of the elections director, that being the day-to-day operation of the division, preparation for and conduct of all primaries and elections, registration of voters. Some of this is kind of what was above. The elections director shall also have the responsibility for the direct supervision of the division's employees. is that something that needs to be in the bylaws? Given the kind of barometer that we've created or used thus far about including items here, is this more appropriate for our policy? The specific duties are enumerated in the job descriptions filed with the Human Resources Department.
I don't really think about the bylaws being where you lay out the job duties for the elections director.
So that would take care of Romanet 3. And if again, if we believe it's important enough for requires, there's a requirement to state it, it can be placed in a policy. So that's Romanet 3. Romanet 4, the election supervisor shall perform such other functions and duties as may be prescribed by the board. I think, again, that's the duties. To Daniel's point, we wouldn't necessarily use the bylaws to lay that out. So that could get kicked to a policy as well, Daniel? Okay.
So that whole section then.
Yeah, I think. However, number 5. Or Romanet 5, I think. Does remain. The election supervisor shall be subject to removal at any time for cause of notice. Because I thought I saw that in. Yes, that is presently in the original draft. The
That's
election
taken straight almost directly from the.
from the code, right?
Local law. Nation legislation.
So Romanet
So that can stay.
3 would come out, Romanet 4 would come out, but Romanet 5 would remain in. And then I think Romanet 6 comes out because that's just kind of what would take place in the event of a planned or unplanned continuing absence. That's more like administration and less language that was codified in law.
Right.
So what are you saying for?
I don't have a problem with 6 because.
Okay.
I think 6 needs to be left in there.
Because what we're talking about there is like,
The employee of an interim.
what you're saying, we say above, like you appoint and
Mhm.
remove, and then here you say, get a little more detailed, say, appointing them to do this thing, and it's, I think what 6 does is it says, look, if there's somebody, somebody's not here, I think that's good to have in bylaws.
Okay, got it. So in summary, the board delegating powers comes out. The elections director shall be responsible comes out. So the only thing that we're keeping here is Romanet 5 and Romanet 6. Subject to removal and then in the event of a planned or unplanned continuing absence. Okay. And then this, I'm sorry.
Are we keeping the? I guess it's one, the board shall employ, that,
Oh, yeah, that comes straight from the,
yes, okay.
yeah.
We're taking out 2.
3, 4.
5 and 6 are staying.
5 is staying. 6 is staying.
3 and 4 being removed, we're going to make a policy. For this, 5 and 6.
2 is coming out as well. 2, 3, and 4
2, 3, and 4, great.
are out.
Thank you.
I think we need to split 6
Mm-hmm.
into sentences, and I might clean up that portion too.
Okay. got it. And then the language that was stricken, some of that is just duplicative of language that was already here. However, so what is now deleted subsection 4, Romanet 4, that spoke to the 4 years until a successor? There was a question that was raised about that. Why are we limiting the number of years to a specific period? It would relate to the language that's in Romanet number 1. But then Daniel responded, under the enabling legislation, the election supervisor is appointed to serve for a period of 4 years until his or her successor is appointed and qualified. So one, if this language, it tracks with local legislation.
Yeah,
Then-
basically takes contract or director's contract, it should be for 4 years.
Okay,
And renewed every 4 years. That's what's kind of news to me. I was like, oh, I didn't know that.
yeah.
But that's in the enabling legislation.
So then
So we
this
try to
language
fix that
should,
code.
well, I was gonna say this language should be combined with what is in Romanet 1, where we are pulling a full-time
Yeah.
direction and then.
To serve every Korean.
Exactly, and then to Jennifer's point, the section reference of the enabling legislation can be referenced there. So that comes back in, notwithstanding the fact it's deleted. Quarterly annual basis, the board, that's kicked to a policy we've already talked about, the board evaluation of the director's performance.
Just added this, enabling a lot of things to make it fair, that's where that language came from.
Okay.
Cause then it's not gonna get questioned. I questioned it too. I was like.
And then the continuing absence of the elections director, no individual member of the board shall direct or discipline any employees under the direction of the elections director. I think we were ever in jeopardy of that, so. But it's been deleted. I think that's goes more to process, the administration of the office, so that would be out as well.
Make 6.
Well, 6 is already,
6 is covered for.
it's covered in the 6. Yeah, like it's just, language has been,
This.
Right,
Yes.
I don't know what this is, so,
you're good.
okay,
You're good.
okay,
Yeah, you're on the right, yes.
okay.
Same thing.
Other employees, physical facilities, again, this is language that I believe comes straight from the current, and then Daniel has supplemented with the enabling legislation reference. Same with parliamentary authority. That comes from the previous version, Robert's Rules of Order, Robert's Rules of Order governs unless otherwise stated. Amendments. The language is the same verbatim at 15 days.
The original draft had 5 days. And I suggested
15 to go back to what, yeah, I'm sorry, when I said 15 days, when I said the original, I was talking about the original that we began working from, the original, not the proposed amended.
the current.
Yes. Okay. And then the only other thing is certain items did not, well, we've got the resolution of conflicting provisions. That language is I think the same. I would tend to think that wouldn't be objectionable. And then the things that did not make it from the current bylaws would be the seal of the board shall be in such form as shall be approved from time to time by the board, subject to applicable law. We've never really done that. I don't know whether that needs to come over. I didn't think it needed to, but if we need to bring it over from the current bylaws, we can. And then the other is notices. Each member of the board shall file. This is, if you're looking in that current, it's section 7 and section 8. Again, it's the current bylaws. Each member of the board shall file with the board a current mailing address and telephone number at which the member can be reached. This filing shall be amended from time to time. If written notice is required at any time, such notice shall be sufficient if personally delivered to the member within the time specified, placed in the regular mail. We're not doing any of that, which is the reason why I did not bring it over.
No, I agree.
Okay.
Yeah.
All right.
It's very productive.
All righty, there we go.
Got over.
Yes, lots of homework.
Looks like they have a run.
Great. All right, so Daniel, thank you for picking up that task. I will note that we previously talked about whether this evening is the appropriate time to undertake a review of the proposed revisions to the policy statement on meetings of political party chairs and representatives. I'm happy to entertain a motion if anyone
I
believes
move-
otherwise.
I move that we table that to a later meeting. not tackle it tonight.
Second that.
Okay, it's been moved and properly seconded to table the second item under old business, which is the statement on meetings with political party chairs and representative. All those in favor, if you'll give a voice vote.
Madam Chair.
Yes.
Can we have a
Discussion?
Thank you.
Sorry about that. Moving too fast. Yeah.
I would like to amend that motion to include a regular meeting, so that it is before the public and allows them to comment.
Sure,
Okay.
I accept.
You want to say, you mean the regular
Do you-
monthly meeting as opposed to an election meeting? Is that what you're saying?
No, just
Because this is technically a
regular
So
meeting,
you're saying a regular.
a regular monthly meeting.
A regular monthly.
You just want to make sure there's public comment or whatever. the
Right.
meeting. We're trying to make sure there's public comment at the meeting where we do this discussion.
Yes, okay. So the motion as amended is to table item number 2 under old business policy statement on meetings with political party chairs to be taken up at a regular monthly meeting at a later date.
Do we have a second to the?
Okay, it's been moved and properly seconded to approve the amended motion. All those in favor? Aye. No opposition, motion passes unanimously. Next up is executive session, although we do know, I presume everyone is returned.
Yes.
So,
I have unofficial incomplete results for,
Okay.
I wanted to note that online it does show that Kennesaw 1A is outstanding. That's because they have 0 voters, so they have been reported. And so that's why it shows as only being 97% reported, but we are 100% reported. There are only 140 voters in Kennesaw 1A that were in D2. It was like one or two neighborhoods that got put into D2. So they had no voters since right now. But we are fully reported.
that raises a question as to whether we should, and maybe we take it up. Whether we should have that precinct open for the runoff election, but I didn't want us
I mean,
to.
they can't move those voters in between hours. So there's no, unfortunately, we can definitely look at it straight.
On a go forward basis.
Yes.
So just so I understand, there are voters in that precinct who are in the wrong
No,
district?
they're not in the wrong district. There's 140 voters, it's split precincts. So some voters that Kennesaw 1A are District 1, some are District 2. Only 140 voters have that precinct or District 2, the rest are in District 1. So it's just a really small, that's why it was 0 voters. It's not like it's 0 out of 4,000 voters. I think the whole precinct is it's a really small part of that precinct.
And they did run the zero tape, right?
Yes.
Opening and close.
We
Just
we
checking.
uploaded the memory card, so it shows it's 0, but when you upload a 0 to the ENR, it thinks that it means that it hasn't been uploaded, but everything on the EMS is fully uploaded, so you'll see that in the summary report that it shows 0 votes.
And hopefully staff or whoever, the poll workers were saying, nobody came in today.
Yes, we knew pretty early on, so we checked the check-ins on the poll badge of the day, we checked them with them, because it was showing syncing. They had no voters, they confirmed they had no voters, and they were very sad when they returned their supplies.
What a day.
Oh, that's feel like a waste of a day working demands.
I'll send them a handwritten.
Okay.
And we are going to run off.
Yeah, we'll be having a runoff and I should have said that, I apologize. Democratic D2, between Eric Allen and Java Howard, you can see we had, I don't think they'll have it of math in public, but I believe that's 101 vote difference between the two of them. So you'll notice Tanisha Horton is not listed on the report because she's withdrawn, so all of her votes are validated. So it's just, it's listed on the report and that's what's listed on the ENR as well.
All right. So we are at a point in the agenda that executive session is the next item, and I do believe it's necessary for us to have an executive session. So,
I'm gonna go ahead and just point out to the upcoming meetings.
yeah. Upcoming meetings, February 14th, 2025, that's our pre-cert meeting. It will be held here at 3 p.m. Following Monday, February 17th, we will have our regular monthly meeting combined with our certification meeting, at which we will undertake certification. Again, 3 p.m. VOC room, 100 Cherokee.
Can I have one thing about, so now that we're having the March runoff, we won't have the meeting on March tenth, right? We just have the,
Right, it'll be,
just to clear, I just want to look at the calendar, so we're all,
March 11th for the election,
right, so
March 17th.
or for pre-cert.
11, 14, and 17 will be March, and 10 will not have.
It's the same dates as this one.
Okay, oh, good. And you'll get that edited, if you don't mind, after tonight, maybe tomorrow, we'll make sure that's updated on,
Consider it part.
yeah.
Cool. Anything for now, Jake?
No, I just feel like,
We moved into the clearance.
Thank you, Mr. Rudy.
What purpose?
For purposes? Personnel.
Personnel.
No.
Legal.
Yeah, do you want to talk legal? Wait, I can give you some, I'll give you a really short legal update.
Okay.
Right, like,
Really, really short?
yes.
So there's a motion on the floor to move into executive session for the purposes of discussing a personnel matter as well as to be provided with an update on current litigation. Is there a second? Second. Motion's moved and properly seconded. All those in favor? Aye. Motion passes unanimously. Thank you. Okay, yes, please do, because I went on a recess. And 10:25, the meeting is adjourned. And CP and crew, thank you. I really appreciate you. Y'all have a good night. We're good. Thank you, Tank.